the trial. We already have Detective Carter, who was on the stand yesterday. Detective Carter, you remain under oath, and you may proceed on behalf of the state.
Oh, Detective Carter, I'll apologize if we rehash anything that we ended on yesterday. During your interview, you conducted a phone interview with the defendant.
Yes.
And then you did some additional research into his records.
Yes.
That research led you to want to speak with him in person.
Yes.
Did you check on any other avenues of investigation as far as other people went, in particular Scoop?
Yes, I did.
How did you determine what, if any, role Scoop had in Tori's death?
His name came up multiple times while interviewing witnesses in the case, as well as Mr. Ford. Mr. Ford also indicated that he had contact with Scoop that night, as well, and his records also indicated that. So I obtained Scoop's phone records, or Jerron Thompson's phone records. Same person, it's his alias. I obtained his phone records as well as his Instagram records. And the night of the incident into the next morning, on Instagram, Jerron was communicating with a female and discussing coming to see her. And his phone records did not place him in Stone Mountain, Lithonia, any of the areas that were associated with the case at the time of the incident.
And so did you clear Jerron Thompson of any, as a suspect in the death of Tori Lang?
I did, based on his records.
Did you interview the defendant?
Yes.
Where did you interview him?
At Clayton County Jail.
Did you inform the defendant of his rights?
I did.
What rights did you inform him of?
His Miranda warnings.
Do you recall specifically what you told him?
When I was saying his Miranda warnings?
Yes.
Yes.
Can you tell the jury what rights you informed the defendant of when you interviewed him?
Yes. May I read from my card? I don't know it by heart.
Did you read from your card when you informed the defendant?
I did.
Then yes, read from your card.
You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish, and you can decide at any time to exercise these rights and not answer any questions or make any statements.
Did he appear to understand his rights?
Yes.
Did he agree to talk to you?
He did.
During the course of the interview, did the defendant have any questions about his rights?
No.
Did he ask you to see an attorney?
He did not.
Did he ask for an attorney to be present during the interview?
He did not.
Was he threatened in any way?
No.
Did you promise him anything?
Just that I would review all the evidence and try to make the best decision.
But did you promise him a benefit for speaking to you or for interviewing with you that day?
I did not.
Did you deprive him of food or water?
I did not.
Did you threaten him, beat him, pull a gun on him, a taser, an ass baton, anything of that nature?
I did not.
Now, he was in custody, was he not?
He was.
Was he in your custody?
He was not.
At this time, were there charges relating to the death of Tori Lang pending against him?
There were not.
What was the substance of your interview with the defendant?
I initially asked him to give a summary of the case to Detective Jorstad. I then began explaining to him the evidence that I had obtained from his records, as well as showing it to him and let him know that based on the information in his records, what he was telling us wasn't true, and I expressed how important it was for him to come forward and talk to us about it. From that point, he did change his story again and confirmed that he was at the park, and he said that Tori drove him to the park. He didn't know where he was going when they were on the way to the park.
Judge, I'm just going to object his best evidence. I mean, obviously, if he's going to play it, he can play it. I'm going to object to summarizing it if it's going to be played for the jury. Best evidence is my objection, Judge.
State's response.
It will in fact be played, but I don't know that the best evidence rule, since this is not the only evidence of it, applies here.
I will allow it over objection, but the jury will determine from the recording, which is expected to be tendered by the state, what was actually stated.
Thank you, Your Honor. Please continue, please.
I asked Austin, because in his records, why he turned his phone off, because it appeared to be done so prior to getting to the park. And he stated he didn't know that they were actually going to Yellow River Park, and he said that he did so because he was scared. And when asked further, he said, I don't know, I was just scared. That was his explanation. He said when they arrived to the park, they began walking to where Tori was later located, and Tori had the gun in her hand. He said while walking there, he was able to get the gun from Tori and set it on the ground. And he tried to give her a hug. And then when he attempted to give her a hug, she pushed him away, reached to the ground, picked up the gun and fired it, causing her to immediately fall to the ground. He said he did not touch her in any way. And he then ran in a circle for a second because he freaked out. He then picked up the gun and drove away. He gave two different statements in regards to his reasoning for picking up the gun. He said first that Tori told him to get rid of it or sell it. Or he said Tori told him to sell it, and then Tori told him to get rid of it. The car, he said he was instructed to park the car in a cut, or that's kind of like a street term for like a little parking area that's not it's not a parking area. A cut is like a little spot on the street, I guess, is what he was referring to, off Rockbridge Road near a neighborhood. And then he said he went home and he never spoke to anyone about the incident. When asked why he didn't contact police or report it, he said he was afraid because he was black and she was light-skinned.
Are you given by the Gwinnett County Police Department a body-worn camera?
I am.
Familiar with how to operate it?
I am.
Did you have it with you, and was it operating on the day you interviewed the defendant at Clayton County Jail?
I did.
Have you reviewed the recording from that body cam?
I have.
Is it a true and accurate depiction or a true and accurate recording of your interview with the defendant, Austin Ford?
It is.
And have you reviewed the copy of it that is in the possession of the state?
I have.
Has it been altered in any way?
It has not.
Is it contained on the same thumb drive as the audio recording that we listened to yesterday?
I believe so.
Your Honor, the state would tender 15H, the video recording of the interview with the defendant at Clayton County Jail.
15H.
Yes, Your Honor.
Any objection?
My only objection is pursuant to the motion that we addressed before trial. Thank you, Judge.
All right, and subject to the court's prior ruling, then this 15H will be admitted over objection of the defense.
Thank you, Your Honor. At this time, I do intend to tender 15H.
All right, and is it audio and video?
It's audio and video, and it's approximately 1 hour, 13 minutes long.
All right, let me give you all a limiting instruction for your consideration before the exhibit is published to you. Members of the jury, you are about to see and hear an audio and video recording of an interview between Detective Carter and purportedly between this defendant. As you view and hear the video and audio recording, you will both see and hear the interviewing officer make certain statements to the defendant. I caution you that the declarations or statements of the officers are not evidence, and you should not consider such statements as evidence unless such statements are proven to you by other competent evidence. You may now publish.
Thank you, Your Honor. everybody can have the same 30-second?
Yes, it has a 30-second delay when you press the button.
Yeah. You want me to do a practice or close it completely?
You can practice, fine.
Yeah, practice. I know how some people don't want to do it. Yeah.
Dude, what the hell? You know how I found out she was here, right? Miss Teresa, not Teresa, it is Teresa, yeah. I was about to call her, Tanya. Tori's mom. Yeah. I don't know. She was like, you know, I was thinking of a lot of stuff. What? I was like, no, you did? So you probably know who I am. Yeah, so she called me. It was like, he's locked up. I was like, for what? She's like, did you charge him? I was like, no, what are you talking about? And I was like, shit, I've been trying to find him. So she told me today. So that's why I was like, I'll just write it down here.
I thought y'all were in Gwinnett County. I thought y'all were in there.
I didn't know he was locked up.
But what happened was I had about an argument with my girlfriend, and I just we was trying to get away from her. We was outside being loud, and somebody called the police, and then he found a gun on me and stuff like that, and
Yeah.
took me down here. And I had the spank screens, I had a hold on me and stuff like that, so.
Yeah. Well, you knew about that one, right?
Yeah.
Because I told you about that. But, well, since obviously, you know, we're not here to talk about that, I just was like, you're here. You know, I know you're going through it, but this is a good time for us to sit down and talk. Since this is Detective George's dad. Okay. Yeah. I just have to read your Miranda warnings because we are in a jail. And you can't just like get up and leave. You're not like free to leave. Does that make sense? So with that, we have to read Miranda warnings. This place is echoing so loud.
This place is horrible.
Yeah, let me just read this really, really quick, okay? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you. Before any questioning, if you wish, you can decide at any time to exercise these rights and not answer any questions or make any statements. Okay? All right. So, what was y'all fighting about?
She said I wasn't being a man. She said like we went to go get some stuff in the store and it came up to $300 at Family Dollar. And I said, you know, when I'm going to the store, I said, that's too much money, that's too much, that's way too much.
$300 at Family Dollar.
Yeah, so
a lot.
Yeah, and so she was like, oh my, I'll get some. I said, okay. So we got to the cash register, and I said, okay, so how much you gonna put down? How much you gonna put down? And she was just like, you're gonna divide it up or something like that, and then she put it in the calculator, whatever, so 140 or something from each of us. And then I was gonna get 140, and then she showed me my bank account, she had like $80 left. So I said, okay, let me go get the rest of the money. So I went to go get the rest of the money, and I came back, she stormed out, and I'm like, she left me with the bag, and I said, what happened? She said, I paid for it, or whatever. Oh, you want to pay for it? I want to pay for it. So then she get mad, she crying and stuff, so I just gave her $200 because she had to pay the phone bill and all that, so I'm going to pay for it,
Yeah.
And then she still is mad, and you're not a man, I would never let no woman pay use the rest of her money for whatever, but it's all this stuff you want to do. It's all this stuff you want to do.
And she knows y'all are going through it. Like,
yeah, and she just, man, it just happened. I was gonna leave, but I was gonna just be homeless. I was just gonna be homeless. And the police pulled up behind us, and that's it.
and then they found a gun on you. But how you get that gun? I saw what the charge was. I don't work. This is not my jurisdiction, so I'm just being nosy. But what the hell?
Whatever I say,
It's not.
No.
Like that, I'm only here to talk about Tori, but I'm just being nosy because I'm like, you're not a bad guy. What the fuck, bro?
But I gotta go because we had to start going through a lot of stuff.
Yeah.
So we were homeless and all that, so I had to protect my family. So
Yeah.
I didn't know it was stolen.
Who? You bought it from somebody?
I didn't know it was stolen or anything like that.
Yeah.
You get like off the street from somebody?
Yeah. I got 2 more months till 21. So, and I didn't have enough for no.
That's right. I didn't even think about that.
Yeah,
I'm sitting here thinking like, just go to a pawn shop. I forgot you were under 21.
I didn't have enough money for no big old long,
Yeah.
So I just had enough money for that.
Don't protect nobody. You better be like, I bought this from so-and-so because you were so young. Like, don't fuck yourself up, okay? When you go to court and everything for that situation, make sure you,
I am.
yeah. Okay.
But we're not gonna keep you too long. I don't know what the schedule's like here, so I don't wanna mess your routine up. But Detective Jorstad's kind of new to this case, and I'm gonna pull some stuff, because I've been trying to pull it up while we were getting up here, but my computer just came back on. If you could just fill him in the day, like that morning when you were looking for Tori, because she had your wallet.
Okay, so what happened was, the night before, I left my wallet in my car and come home and sleep stuff. And then I was going to buy something. I was going to just get something. And then I was looking for my wallet. I realized I left it in the car. So calling Tori, Tori not answering, kept calling. And I went to her house and I spoke to, I think, when we talked the first time, I spoke to her dad or somebody. I think I went knocked on the door and they didn't no answer. I went back to her house and I think I spoke to her dad. And then I went back, that's when I seen on the camera and stuff like that. And then, later on, she had came to my house, looking like spigots of weed or whatever, to calm down. But at that time, I was like, what's wrong with you? I've been looking for you everywhere, and I can't find you and all that stuff. And so she's like, I'm just trying to be by myself. I'm just trying to be by myself and stuff. So I gave her some weed, she let me went outside, some of my girlfriend. Said, something wrong, something's wrong. So then later on, I went back and later on she came back talking about she wanted to kill herself and everything and all that. So I was crying to her, saying, you got a lot of love, like I knew you all day, like people love you out here. Yeah. So I was telling her that she didn't want to hear it. She didn't want to hear it. I tried to love her, she kept pushing me off of her and everything. And then so she had left. And then I called my friends, smoked and stuff, and I'm just real emotional about it. I don't know how it's gonna go on. I don't know. And so my mom called me and was like, did you see Tori or whatever? And I told her no, because Tori told me not to tell nobody when she left or whatever like that. Yeah. And I think a day later or 2 days later or something, he said, yeah, I found her in the park or whatever. And I just don't know at the point. So that's pretty much it.
Yeah. Did she say where she was going?
No, because the first time she came, I said, where you at? Where you going? Like all that, she wouldn't tell me anything. She said she just needed to be by herself. She just smoked weed and chill out and stuff like that. She didn't say nothing. Yeah. That's pretty much it.
Yeah. And then you didn't leave the house other than to walk up to the gas station to buy, what's this thing? To buy weed. But it wasn't at the gas station, it was near the gas station, right? Okay.
Yeah, like behind on the side of the gas station.
Okay. Sorry, I'm trying to get this all up.
Is that the basement?
Yeah, this is stupid, man. This one's stupid too.
Was it Leopard Lizard? Yeah. I've seen a lot of people with that.
It's really cool, but I passed out on this one.
Did you?
Mm-hmm.
Right.
Really?
Yeah, I passed.
Oh, right there?
Yeah.
I can't get them right there, so I don't know.
Yeah, we can't have anything below.
Okay, so, and then, who all did you call that day?
I called my girlfriend, I called my friend.
You called your girlfriend?
I think so.
I thought she was at your house.
Yeah.
Oh, okay.
Yeah, so,
You called her while you were at the house?
no, I called her when I was coming back. From the weed man.
From the weed man, like after midnight?
Yeah.
Okay.
I called the weed man.
Okay. No, I meant like, who were you calling trying to look for Tori? I'm just trying to give him some backstory before we go.
I called her tall gay friend. I called her. I called the short Jamaican man. I called him. He one that actually took me to the house to find my wallet over there.
Is that Ja?
Yeah, John. And who else I called? I don't know. I don't remember who else I called.
Okay. I was just wondering. And I never asked you, I thought about it. So the way the timeline worked out, so you tried to reach out to all those people on, this was the 27th. I know it's been a little while, but we found her on the 28th, but we didn't identify her till the 29th. Did you try to reach out to her at all on the 28th? Or anybody trying to get her? Because you didn't get your wallet that night, right? So you still needed it, but did you try to call her mom, call anybody on the 28th?
I was just talking to my brother all the time, saying all my friends are always good and stuff.
Mm-hmm.
So
Okay.
Like, y'all like best friends, y'all super tight?
Yeah, we was super tight, yeah.
How long y'all known each other?
Jail sucks, look at this, just circling.
Ninth grade, 10th grade.
Oh, wow. Y'all went to say, what's high school y'all go to?
Spears High School. You from here?
I'm from, when I was Brooklyn.
I'm not from here.
Yeah.
Hollywood.
There's like 4,000 kids in Brooklyn, it's a big school.
Okay. Do you remember about how long, because there's so many facts into this case, how long was it after she left the last time, after she told you because she asked him to kill her, right? With the gun that you saw in the car. And you said no, obviously. You hugged her and she left. Then you went back upstairs. Do you remember how long you were at home? Was it a couple hours? I think it was.
I wasn't home, I was trying to straight away from weed.
And how'd you get there?
Oh.
Okay. Because I think we see her, how long were y'all outside for?
I came like 15 minutes or so.
Because you guys walked down the stairs, I think at 10:40, but then you don't leave your house till 12:36 or something like that. So about 2 hours? Okay.
I know I went to go get some weed because I know I was in my head. Because Tori is always like that. She was, she always battled with that. And I just was falling right in my head.
Was this the first time she ever mentioned suicide or anything? No.
No, because I've been through a lot of stuff in my life and stuff, and she would always tell me it's not that hard. Like you don't bad as hard. So she showed me a book. Like she be praying for death. Like she be praying to God for death. Like so she didn't.
She prays to God for death.
Mhm.
I didn't hear that one.
I'm saying it's a whole, she got a book, it's a blue book, and she had prayers about like she don't want to be here anymore.
Wow. That's heavy.
I think we have something like that.
It's not new, it's not, me and her are always talking about it, because I was going through a lot of stuff too, and she was helping me, but she used to go through a lot of stuff too, so we were trying to help each other.
Yeah, absolutely. What was her like biggest thing of not wanting to be around?
Her just wanting in love, yeah, because she was kind of heavy set, so she didn't feel like she was loved, she didn't feel like she was pretty, she didn't feel like, nothing about her whole stuff, like it was pretty, like, a lot of dudes like you and all that stuff, but she ain't,
She liked Scoop, and he was an asshole.
yeah.
I got his records, his Instagram records. And we know, like, he didn't do it, so. Because you talked to him that day too.
Mhm.
Yeah, he was out with he was talking to some girl and was running around with some girl. He didn't even seem sad, like, after people was hitting him up afterwards. And
He kind of sad, like, he was acting kind of, I told him to tell it before.
yeah. I think but he just doesn't seem sad, you know what I mean? Like, because he's immediately asking for, like, perks, and, you know what I mean?
Yeah.
Like, when people ask him, like, are you good? He was like, yeah, I'm good. You got some perks. But then he's trying to hit up other girls, too. I'm like, he's just so disrespectful. But yeah, he wasn't even in that area, so I know Teresa was super adamant that it was probably him.
She know I got looked up.
She told me, I don't know, she knew that, I guess, Marquez's baby daddy got locked up a minute ago. She told me about him. She was like, you need to go talk to him. I was like, I'm not going to go talk to him. I don't have reason to go talk to him, because unless you think of something, why I should go talk to him, but I didn't have anything to show that he was involved, you know what I mean?
Yeah.
But when she told me you, I was like, oh, perfect. And I wasn't trying to be rude in the text message. I was just like, dude, I really want to meet you in person.
I don't know.
Okay, let me pull up this thing.
Have you ever found a job? I mean, before this, were you ever like looking for work or anything? Yeah.
I had a couple jobs. I worked at FedEx, Walmart, and FedEx again. And then I worked at construction.
Like I said, try to get on like one of those Amazon fulfillment centers. I mean, you work all hours of the night, you just shipping the packages and making good money.
When I got here, I'm going to home shelter.
Yeah,
Mm-hmm.
thank God.
You're going where?
Home shelters. But it's cold again. It's below 20 degrees now.
Yeah.
Yeah.
I get a coworker, he bagged ice. Like he worked at an ice bagging facility, so he didn't even like to touch cold drinks because from working in there it was so cold. I was like, man, bagging ice.
Okay. I know we talked about it, but Just so he's clear, so he walked, he didn't have access to a car or anything, and your girlfriend has a car, but she didn't have it then.
Yeah, she did.
Did you borrow your mom's car or anything? Okay, all right. And then you still had your cell phone, you had the same cell phone but you just got a new one recently when that one broke, right?
Yeah.
Okay, so that phone wasn't stolen or anything, you still have the same phone? Because it does show you walking up there between the times. Let me see, why does this take, everything is so slow in here right now.
Green County.
I know.
It's all concrete.
How have you been doing?
I've been just trying to hang in there.
But what happened? Like,
So, okay, let me say this.
I talked to your mom a little bit and she
Yeah,
said,
keep that there because I don't know. My mom kicked us out, and then we went to my girlfriend's uncle's house. Then he sold his house. Then we went to my the other uncle's house, but he got to fighting. Like my uncle, her uncle, and her got to fighting, and we got kicked out of there. And we just got a little. We staying in a hotel right now.
where y'all staying at?
Flat shows.
Okay. Her baby daddy don't pay any child support or anything? Has she tried to put him on anything?
I don't her mom, he having all that stuff, but I don't know. He should be sending $25 here and there.
Just $25?
Yeah.
Does he see the baby?
Yeah, on FaceTime, yeah. He lives in New Jersey.
Oh.
He came like 2 weeks ago to chill or whatever, and that was it though. He might,
Yeah, I see. So that's where he lives, and then you walked up to that BP station? Was it like over here somewhere where you went? I know we referenced the BP, but...
Yeah. The water, when I went to, wait, hold on. That's the BP. Where's the water's edge at?
You walked the water's edge?
I went through, where's the water's edge? I went through the cut over here. It's like you go down here, you go through there, like a little cut over here. And I went to the water's edge over here and got the reading and came all the way up.
Over where?
Like, okay, so from my neighborhood, there's a bumper road back there. It's like a bumper road. So I went through that neighborhood and I cut through that neighborhood to get to Lake Shore. When I got to Lake Shore, I went through over there to go to Water's Edge.
Here, I'll pull it up. I'll do Google Earth.
I went to Water's Edge and got the reading and came back up.
Okay. Because you told me it was near like the liquor store and BP gas station. I forgot what you live on here.
That's the computer?
Yeah. Making that noise?
Yeah.
Yeah. So that's where you live.
Okay.
So where are you trying to show me?
This is where I live. So,
I think it's touchscreen, so you can move it.
okay, you see. When I come out of here, when I go into this neighborhood, it's down here, I come down here, and come down here, it's like, it's a cut somewhere. It's a cut that I can get to Lakeshore. Where's QT at?
You walk the QT?
Yeah, it's a cut that you can go through to go to QT.
I don't know, you tell
The
me.
QT on Rockridge and North Shore? Gotcha.
Well,
Yes, that's gonna be, yeah.
Like way up
That's
there.
like, the Quick Trip should be around there.
I went to QT and walked all the way up to Water's Edge through here.
The quick trip right here?
Yeah,
I walked like, where's QT?
QT's right there.
So,
on the corner.
where's Lakeshore? This Lakeshore?
That's Woodstone.
Water's Edge,
North
that
Shore.
neighborhood across the street.
Oh, this one over here?
That's Water's Edge. I used to work down there, so I know.
That's Glen Cove. QT's right there, Publix is right there.
Okay, good. So I ran through a cut to come over here, or come over here in this area, and I just walked down to Water's Edge and got the weed. But,
And then you walk back?
yeah, I walked all the way back from BP to my house.
Okay.
Did you get the weed from someone in the neighborhood or someone at the BP?
What neighborhood?
We went to somebody's house. Yeah.
Oh, so you plugged in the Water's Edge neighborhood?
Hold on.
Oh, it's kind of hard to
Well, this
I'm
is-
just walking, I can't,
Yeah, it's easier when you're walking to know where you're going than it is when
This
it's
is
found out.
how
Yeah, because it doesn't show the cuts on
Yeah.
the flare. Yeah, I worked down in that area, not side, you know, the
Yeah,
funds
so
over
that,
there.
that is right there. I know,
Yeah, I worked down there for years.
I mean, more towards it's almost 2 miles.
He used to walk everywhere. I'm from New York, man. I walk everywhere. I really didn't know he wasn't this big before. I used to be skinny.
You were not big.
I mean, I'm saying now, like now, my size now, he's 205. So I used to be 170.
Yeah. How tall are you?
How tall are you?
6'4"?
6'4". Felt like, Jesus.
Yeah.
Maybe like 5'10"-ish?
Nah,
5'11"?
I'm 6
You think 6 foot?
Yeah.
6 flat? I think it's 6 flat.
Yeah.
I want to open these things so I can show them to you, so we can just make sure we're talking about the same time, because we got to bring video. I just want to make sure that's when you left. So you went, so after Tori left, you went back upstairs for a little while, right?
Yeah.
Okay. And then you only left to go get weed, and then you came back, and that was the time that Detective Smith told you about, right?
Mm-hmm.
You didn't leave any other time?
I did. I left to go down there and smoke with my friend. And then
Was that before or after,
after she left.
after she left? And you only walked up there once? Okay. So, let me see. Why is none of this is pissing me off? I should have put all this up in the car. It was giving me issues in the car though too. But you drive is apparently empty.
Yeah, probably because we're so far away from Gwinnett.
I think it was building. I have it in my phone now. I can look it up. It was raining that night, wasn't it? Did it not rain that night? Okay.
I think it rained that morning.
Yeah.
But that morning, I think it rained that morning. 'Cause I didn't give it out.
How you been dealing with the loss of Tori?
I'm afraid. I don't know, it's been hard all over. It's been hard and just, I would just take a day at a time, really. Sometimes you get sad, sometimes you cry and stuff, because I be wanting to talk to her. And it's one thing like, I used to talk to her every day, man. I used to smoke with her every day.
Yeah.
And it's hard, but you know, here I talk to my girlfriend all the time, like, about memory something, like, I need to told me to do that. And,
Yeah.
like that, so it's been hard.
Yeah.
Everything been hard, man, so I just been numb to everything, like,
I know I have it in my phone from Smith, so I'll just pull it up in my text messages. Okay. So, did she tell you she left the wallet in her mailbox? She did? When did she tell you that?
when I was downstairs, when we went downstairs.
The last time before you saw her? Okay, so she told you she had left it in the mailbox? Okay, but she didn't tell you when she came at 7 o'clock that day? Did you ask her about the wallet when she came the first time?
When I seen her, I was not thinking about my wallet, I think about her, because I was, you know, looking for you, like, where you been? I'm trying to make sure you okay and stuff.
Yeah.
I didn't think about my wallet.
Okay, so this is her, and it's 10:28, so that's right before she came to your house. And here's the rings. Cross your fingers. It's gonna work. All right, I'm not even gonna handle that anymore, so this is getting on my nerves. Nothing's loading in here. Okay, so I'm gonna tell you what we have, and I'm not gonna bullshit you, okay? I'm gonna be completely honest with you, because there's a reason why I've been trying to push so hard to talk to you. Because, you know, I feel like there's a lot more to this story that we're not being told, and I don't want to make assumptions, okay? And that's why I wanted to talk to you in person. I didn't want to go over the phone because, you know, I don't feel like you'd be completely honest with me, all right? I know she had her issues. I've talked to umpteenth amounts of people about her. I've gotten her Instagram records. I've gotten her medical records. I've gotten everything. So when you say she was suicidal, I believe you. And I believe that, you know, she did have the gun. I do believe that you guys were very close. I read messages between you guys. I've seen tons and tons of stuff. The day she left her house was between 2 and 4 p.m. I see the messages and the contact you guys had before she left that day. I don't know what you talked about. You said you didn't really remember talking to her that morning, but it was from an iPhone.
About that morning?
Yeah, before she left her house. When she was telling you, like, her phone was going to be cut off for a little while. Because her mom was changing services. And you talked from a 404-559 number, I believe. It was an iPhone.
Yeah, it was just that phone.
Yeah. So you guys had conversation. Do you remember what you guys talked about?
Remember, no.
Okay.
She remember she saying that her phone would be turned off or whatever, the mom or whatever, but I don't remember anything else.
Okay. So then you told me that you went to her house like 3 times, right? And then the first time nobody answered, but you didn't see her car, right? She wasn't there. The second time you went, her dad was there. You talked to her dad. In between the second and third time, Tori came to your house, right? Okay. So that's when you guys had the conversation about the weed or whatever. And then you reached out to Jaheem. And then Jaheem took you over to Tori's house the third time. Did you talk to anybody that third time?
I don't remember. I don't remember.
Okay. So then she goes to her house at about 10:30. She gets something out of the mailbox. We believe to be your wallet. At 10:36, she's on Ring camera walking upstairs to your apartment. Then, are you left-handed or right-handed? I thought about that. You're right-handed? Okay. And then, so she walks upstairs, 10:36, the camera cuts. Then we see you guys walking downstairs at 10:40. And then, when you get downstairs, what happens?
That's when she said she don't want to be here no more, and that's when I see the gun, and I start crying to her, and I'm trying to hug her, and she pushed me off her, and everything like that. So I said, I'm telling her, like, people love you. That's the whole time I'm telling her, people love you. Don't kick this, don't do this, don't feel this way, don't, all that, and that's she left.
And then, what'd you do?
That's when I went to go get the weed. I sat there for a minute and went to go get the weed and came back on my friend, smoked some weed and came back upstairs.
Austin. That's not what happened.
That is what happened.
So, you remember how I told you I got Scoop's records? I got your records. I got Jada's records. I got Tori's records. I got Jaheem's records. I got everybody's records. Tori and you walked downstairs at 10:40 p.m. You're down there for about 10-15 minutes, correct? At 11:05, you are at North Deshaun Road and Annistown Road. At 11:05 p.m., you are at the corner of North Deshaun Road and Annistown Road.
Where is that? Northtown Road.
You're right there, Yellow River. Right after that, your phone is in Yellow River, even though you try to turn it off because it indicates that it gets turned off. You know you were there, okay? I don't want to assume what happened. That's why I'm just like, I know you cared about her. I know what she was going through, okay? What happened in the park? Please be honest, because we know we have the proof now and the evidence that you were there. If it's left to us, then I don't want to make an assumption. You know what I'm saying? So that's what I'm asking. You loved her. I know you did. You're not a bad guy. You're not a murderer. Your friend didn't want to be here anymore, and you cared about her. What happened?
I didn't do anything.
Okay, then tell me what happened. It's okay, it's okay. I believe you, but I need you. Tell me what happened. Did you freak out?
Freak out.
Like, what happened? Tell me what happened.
I went home.
How did you get from your apartment to that location in 10 minutes? Your Gmail account, a lot of people don't know this. They track how quickly you're moving and then they say what you're in. So that says you were in a car. It's physically impossible for you to have walked from your apartment to that location in that amount of time. Because I tried. I didn't want to believe like this was a situation. I tried everything. And that's why I've been trying to, you know what I mean? It's not possible. I even went out there and walked it. I tried every route. I tried everything. I'm just trying to understand, okay?
I understand.
But what happened?
Yeah, I didn't do anything. So,
I believe you, but I think you know what happened. And if we don't like hear it from you, we hear from other people, or we get all of this proof and we have everything going against what you're saying, it just looks bad. You know what I'm saying? So that's why I'm like, let's just be honest and say what happened, because I believe you. I do. I don't think you I don't think you hurt her, but you know what happened in that park because you were there. Your phone was there.
yeah. I don't want to go to jail.
Okay,
I don't want to stay in jail.
okay, okay.
It just, I didn't kill her.
Okay.
I didn't do anything. It just, after that, I know I'll be sitting in jail.
Why do you think you'd be sitting in jail if you didn't kill her?
Because she told me to, you know, take the car here, take the gun here.
That's what we need to know. You know, that's
Yeah.
fine. I believe you, but that's what I need to know.
And then she shot herself.
Okay.
And she shot herself.
I believe you.
She remember sitting there talking to her, saying, please, like, I love you, I love you, I love you. And
Okay.
so I did what she told me to do.
Okay. That's good. All right. You went downstairs, you got in the car with her, and then she drove to Yellow River, right? When you guys got there, walk me through what happened, because I believe you, but I just need the details to...
Sit in the car, and I'm crying to her, please, like, please don't play, please don't, please don't. And she did. She got in the car, walking, I'm trying to walk and talk to her, and she still just like, no, she don't go, she won't go, she won't go. Because I love you, she's not crying, she's not doing anything, or nothing. So I tried to take the gun from her. I take the gun from her, and she just like, you know, she's saying she wanna go, she wanna go, she wanna go. I said, no. I put the gun down, trying to hug her, and she pushed me away from her, and she grabbed my hand, and she was just
Was she standing up? Was she laying down?
she was standing up. And so I'm sitting there crying. So she told me when she shoot herself, grab the gun, throw the gun away, and she told me to sell her car or anything like that.
Because she needed some money, right? She needed something for... Okay. All right. So where did she park in the park?
She didn't park, she just pulled right up. She just left probably. Like she just stopped right there.
Give me one second. I'm going to pull it
So
up.
I'm familiar with that park, so I used to work down there. So like that gravel-ish area?
Yeah.
But y'all just pull, y'all didn't park in a spot, you just pull up. Gotcha.
Okay. And then you guys start to walk. I'm going to pull up the park because Google Earth is actually working.
How many shots went off?
One.
Just one?
Just one.
Here, give me one second.
That's why
Here you go. So, I'm getting it over so it helps you, because you've only been there a few times, right?
Yeah.
All right, so this is the gravel area.
it's right there.
Okay, so she pulls up right here, and you guys get out and you start to walk?
It's right here, over here.
Okay.
And we're just talking and walking and stuff, and she's telling me, like, just take my car somewhere, take the gun, set the gun everywhere, we need to do. I'm like, no.
And you say you take the gun from her. Were you guys standing up, walking, or had y'all sat down somewhere?
We're standing up the whole time, we didn't sit down. Okay.
Okay, so you got the gun from her.
And I was trying to hug her, but I got the gun from her time, like, don't let this night, let's go on, let's go. And I put the gun down and tried to hug her, and she pushed me away from her and grabbed the gun.
Okay, and then she shoots herself. Does she fall back?
Sure, yeah.
Okay,
Yeah, when she felt the gun jump out of her hand.
all right. And then where were you guys at? Like
Right there.
you know where she was found, right?
Yeah.
By the tree? So is that where she fell, or did you move her
No,
afterwards?
that was when she fell, I didn't touch her.
We didn't touch her.
All right. So,
What were her hands like? Well, how did her hands come to rest? Do you remember?
Just out.
okay.
What about her hair? Anything stand out about her hair?
I really didn't look like I didn't look for her. I just cut the strap the gun and looked.
What did you do with the gun?
Throw it in the lake.
Which leg?
The lake that's right there in North Shores. Like, you go over there and just throw it.
Here, you
Is
can-
it the water's edge lake?
It's a lake that's like from my house. You go over there to the lake over there. And like by the North Shore right there.
So,
Not Horse Lake though.
No.
here you go. So this is your apartment. There's 2 bodies of water.
Where's my apartment?
Right here.
My apartment's right here.
Yeah.
So it's on the back street. It's a little lake right there.
Right here? So it's in front of your apartment, kind of?
Yeah.
So, hold on, I'm
Like,
sorry.
is it that
Is
lake?
it this one?
Where's my, no.
No, this is your building right
It's
here.
over here.
Over here? Right here?
Yeah, it's like down here somewhere. It's down here.
You can drive, you can do it.
Okay, so my apartment's right here. Let's see.
Zooming in like that doesn't work.
Yeah, this is Google Earth.
It's like a little house that have a little puddle right there.
Little pond in front of it.
Yeah, you come down. Let's see. When you come down here, it's like it's a house. Okay, this is a speed bump road, right?
No.
Where's the speed bump road at? Oh, down here, this way. Okay. My apartment right here. It's one of these houses right here.
It's got a little pond in front of it.
Yeah. I don't know.
Sorry, can I see your badge pictures?
Yeah. So then, so did you do that night? Okay, so you threw it in there. What did you do with the car that night?
I took it to where she told me to take it.
What?
What is there? Little cut right there. She said to do it.
Water that you cut?
It's like an entrance, all the entrance that is blocked up by a little fence of sewer things.
Yeah.
Where's Water's Edge on there? Which one is that?
Yeah, it's on Rockridge Road, right? I know what you're talking about.
How did it get burned?
I don't know. She told me to leave it there, and I left it there. So I guess she made
That entrance right there.
Oh, right here?
Yeah. That little entrance that's
Yeah,
on.
the old entrance.
Yeah, it's got the chain link fence locked up.
Yeah.
Okay. Oh, I know what you're talking about now. So you left the car there, and then, so did you leave the car, did you go dump the gun first and then go take the car?
Yeah, I dumped the gun first, and then left the car.
Okay.
But, see, that's why I am saying, because I know, like, that could put me in jail just for being here and just taking the gun to the car and stuff, I just,
But does it feel better telling the truth though?
It does
Like
feel
that's what we
better.
want. We want the truth to be able to tell Tori's family what happened and give them some peace. And it's also gonna make you a big weight off your shoulders.
Did you touch her at all afterwards?
after,
Yeah.
um,
There was just some,
not even on the gun.
so you just picked the gun up and then you left?
I was crying, I was just, yeah.
So how far away do you remember was the gun? Like from her?
When she picked it up before she
herself?
shot herself?
To be honest, it happened so fast, I don't remember, to be honest. I just heard a shot. And to be honest, I heard a shot and then I blanked out, like, it just felt like my soul went out my body, like, with her, like, it just, and I was just standing there and she fell.
Okay.
I was standing there crying, and I picked up the gun and just, I just did what she told me to do.
So did you guys talk about it on the way there?
I kept telling her, like, no, please take it on, like,
Okay. I'm so sorry.
but,
I know, it feels better probably now, doesn't it?
yes, but at the same time,
Jada's mom kind of dropped it a little bit. She said she killed herself, didn't she? And I was like, how? Nobody said that. So like, how do you?
because I told her, because Jenny mom, I told her, like, she told me she wanted to kill herself, and somebody kept saying somebody killed her or whatever, so like, mentally, she killed herself, she had somebody kill her or something, so I said,
Yeah.
but,
Did you talk to Jayla about it at all? Okay. How does it?
it's weird.
That's probably what's been.
Maybe that's, yeah, but I never want this, I never want this to happen. I don't want this to be true. I still want my friend to be here. And
Who did you talk to that night afterwards?
talk to,
Yeah. So while you were doing all of that on your way back, you were talking to somebody. You tried to call somebody on Instagram, and you were talking to a phone number. I think his Instagram, it used to be One Luski.
Lucy.
Yeah.
Um,
You were literally on Rock Ridge when you called him. So.
I'll probably need some weed or something. I need some weed because I'm marking weed I have full of dirt, so I was more trying to get some weed.
So you went to buy weed after that? Okay.
I did get some weed that night.
Okay.
And
Where did your clothes go that you were wearing that night?
it's in the house. We went in the house and it's gone now. I was in a store somewhere or something like that.
How close were you to her when she shot herself?
I was standing right here, so she's about like, where you at?
Did any blood get on you? No? Okay. And you said you didn't manipulate her body at all? You didn't
I
touch
didn't
her?
touch her.
Okay. All right. You just picked up the gun, because it had fallen next to her, right?
But I'm saying, like, most of the time, I have tried to hug her. Most of the time,
Yeah.
I try to hug her, so.
But after she was dead, you didn't? Okay.
Because the scene is,
How did she fall? Was it like straight back? Did she like?
I told her, I blanked out, man. When I heard it, like, I just seen her fall, she just fell. You know, I just seen the gun fall, so she just fell, like.
Okay. All right. I really want to see that water though. I believe you.
But I really just never wanted this to be true. I want my friends to still be here, and I didn't know what happened to me. You know, I wanted to hear from my family, my son, like, baby, I just want to be here still so I can still raise my son.
Yeah.
I don't want to be locked up. I don't want to be someone for a long time with murderers, and I'm not that. Like, I'm not
Right.
that, so.
Did you ever shoot the gun after you picked it up?
There were 2 shell casings there. So the gun was fired twice.
One shot. Only one shot.
Okay.
Not for sure, God.
This is not gonna work.
I mean, I know she only shot herself once, but like, did the gun ever go off while y'all were tussling over it?
You sat it on the ground, or did you sit it on something?
I jumped it on the floor, jumped it on the floor.
Because I mean, the technology now that we can compare the shell casings, and then we know they came from the same gun. That's what we're just trying to figure out where the second one came from.
Well, she did tell me earlier she didn't have the gun all day, like she been trying to do it all day, like, so she had it placed in or whatever, but
Yeah.
it was only one shot,
Okay.
and when it failed, I grabbed it and left.
How did you get back from, after you dropped her car off? You did it that night, right?
I walked back. That's when y'all see me on the BP. I walked straight home.
Okay. I'm just trying
So
to...
what time was this about when all this happened? Was it like right after the last time she came over, and that's when y'all left her?
That's what I never understand. I don't want to be in jail. I know I didn't do anything. It's just, I know taking the gun and taking the car is bad. I can just call the police and just, yeah, but I don't want to be in jail
Why did you turn your phone off
because I was scared.
when you went into Yellow River? Because you turned it off. I think you sent Jayla a text message, right? What did you say in that text message?
I think that everything's okay or something, like I'm coming home or something like that.
Okay. So then you turn it off, and then you turn it back on once you're dropping everything. Okay. How long were you guys in the park before she shot herself?
About 10 minutes or so.
Okay.
I don't know.
Okay, so here you go. Here is the BP. I'm trying to find that house with the lake, with the water.
Where's the
The BP is right here. This is Rock Ridge.
BP?
But it was on,
Okay, so my house,
it was on his street.
Oh, it's on your street? Okay.
Yeah.
Oh, yeah, because you put the car here.
Yeah.
Okay.
my street was a speed bump road, and then like a little house with a little black fence, and so like, what's it called when you fish off of it? And so
The dock, like a little, yeah.
and it's a pond, and go right in there.
Okay, so here's your house. This is like your legit building.
Okay, this way is going down this way is the speed bump road, right?
No, that's 124.
Oh, wait.
This
Down
is speed bump road.
Okay, speed bump road. And I guess this house right here, I think.
This house?
Yeah, I think it's right
I
there.
can get closer.
Yeah,
It's like through those trees, there's a little pond.
yeah.
Let me hover, change the view. I don't know if it's gonna get any clearer.
I think it's gonna get.
This damn thing.
Yeah, but
It's right there.
Yeah, it's the only pond that's on that street though.
Okay. Is it deep or is it?
I don't know, I know it's green. So I'm saying, like, am I gonna go to jail for that? For taking my car and all that?
I mean,
That's here.
it's technically illegal, but I mean, I don't know, man. I gotta figure everything out because there's still some, like, a few unknowns because I just have to look at everything again. But I will let you know, okay? Tonight, nothing is happening. We'll still talk. Just stay in contact with me. What is your deal with getting out here?
I got paid a bond, then I got to go to Sandy Springs, I was gonna finish the bond off.
How much is your bond here? It's 1,000. Is she gonna beat you out?
You get somebody to give me now.
Okay.
You gonna pay it tomorrow.
Okay.
You should only pay like, what, 10-15% of that? So like a couple $100.
No, my bond is 10,000.
Oh, to that, oh, okay, so 1,000 will get you, gotcha. I thought you were just 1,000.
So, I mean, you know, it's out and everything like that, so I know I'm gonna have to do something, like I'm gonna have to sit down for a certain amount of time on it.
Yeah, so you gotta, I'm just thinking. So you got that, and they're gonna come get you tomorrow?
No, they pay my bond.
Yeah, and then Sandy Springs will come get you, but that's a the ticket, yeah.
Yeah.
Oh, I don't have an answer for you right now, because I gotta go back and look at everything.
So for clarification, can you just keep in my mind?
Yeah, so I mean, what you did technically, yes, tampering with evidence, but I mean, we also need to speak with our district attorney's office to see, just because of how this case is, you know, not that they won't prosecute, they might not want to, they might want to, you know, it could be, it's not solely up to us. So all we do is we're fact finders. We try to find the truth, we report it, we write a report, and we send it to the district attorney's office. And at the end of the day, the decision is what they want to do. But I mean, you know, I know this stuff, it's been a while trying to get a hold of you, but now that we've sat down and talked to you, I know I stepped out a little bit, but you know, you've been very honest with Detective Carter, you've been honest with me. You know, I think, you know, hopefully that will show and go a long way.
Yeah, definitely. Okay. Anything else you can think of? Did you talk to anybody about this? Did she say that she talked to anybody else to help me corroborate your story?
What's his name that got locked up? That he's Tori Lang said you go talk to him.
Marquez's baby daddy?
She said, like, only thing she told me is that she asked people to do it. He told me all the time, she always asked people to do it. So I don't know if she talked to anybody to have plans or anything like that or like that, but
She didn't tell you in particular who she talked to or asked to do it?
she told me that she asked people to do it. That's the only thing she told me.
What did you tell Scoop happened?
School, I don't know, but.
Okay. She's so upset that he did this. I was like, I don't know, he didn't do it.
But
Yeah. Have you talked to Draco at all?
Draco, no, I ain't really talking.
Okay.
But
Anybody else?
I told nobody about it.
And you said you don't know anything about the car?
He came to my house when it was burned. He came straight to my house.
Who did?
The detective before you came.
Smith came to your house
As
after?
soon as he
Okay.
got in the car, he came straight to my house.
Okay.
And I told him, I don't know.
Okay.
I just want to be here for my son.
I understand. So you guys were in the car. What made you get in the car?
Me and I was trying to keep talking to her until not doing it, talking her not doing it. And I'm trying to show her that I'm distraught. I was crying like, she was acting really weird. Like, she was not crying. She was not trying to look at me or anything. I was trying to tell her, like, I love you, people love you. Like, something, it was weird. Something was weird about it. Like, I can see her dark. Something was wrong with her. And he just kept saying, day by day, like, she went over.
And then she said, I'm gonna shoot myself.
She ain't never said. She said, I want to go, I want you to do it. And I said, I cannot do that. I can't do that for you. I can't.
So she said, how did the conversation go where she told you what to do with the gun in the car?
She said that after, like, what happens, take the gun, sell it or whatever, do whatever you need to do with it, and the car, sell it, do whatever you need to do with it.
She told you to sell it? But I thought she told you to put it in that cut.
No, I didn't say, she didn't put it, but she said, always sell it, do whatever you need to do with it.
Oh, okay. I thought you said she told you to put it there. So you
She
just,
told me to put the car in that cut.
to sell it?
No, she said, told you to put the car in the cut. You can sell it. She told me to take it there. But she said, you can sell it, do whatever you want to do with it. But you can take it there.
Okay.
But,
So did you get your wallet actually that day?
yeah.
Okay.
Maybe she left right there in the car.
And so she was where she was at, under that tree. You guys are standing under the tree. Was it dark, light?
It was dark.
Could you see each other?
A little bit from the moonlight. That's it.
Okay. And then you get the gun away from her. What is she saying when you're trying to hug her?
Stop touching me. She said, stop touching me. Stop touching me.
And then you put the gun, on the ground.
The gun's on the ground, man. I'm trying to hug her. And when she pushed me over, she grabs the gun.
And she stands all the way up. Was it instant? Like she grabs it? Can you just motion it for me so I can understand? I'm sorry.
So you're me, right?
Yeah.
So I'm trying to hug her and stuff, and then, like, she puts off me, and she grabs the gun.
She scoops down and and then what?
She grabs the gun and just
Pop, and then she just goes straight back? Okay. Where was the gun at?
It was like, what's it called, about the roots of the tree.
So did it fall by her feet?
It fell out of her hand. It fell out of her hand.
Okay.
It was above her.
Okay, so when she fell back,
It was above her. And,
did she move or do anything afterwards? Some people don't die instantly, so
did she move? I don't know. I was there.
did she make any noises?
I was just over there crying. I was crying loud. I was crying. And I was grabbing the gun and left.
Was it instantly you grabbed the gun and you left?
It wasn't instant. She shot herself, and I'm sitting there crying. I'm crying. Oh my God, I really wasn't even. I was running like running in circles.
Yeah.
And oh my God, and I heard her. I don't know, but I heard a little like I heard it, and I just grabbed the gun and left.
Okay.
And I know I should have just stayed there, called the police and everything, but it's a violent from me. I don't know what to do. I'm black. I'm talking. It's terrifying. She's light skinned, and I know how the world is. I just know how the world is, and I just did what she told me to do, and that was where I messed up at.
Okay. I'm trying to, and I'm only asking, if I come off harsh, I'm not trying to be harsh. I'm trying to get the answers that I need to be able to answer for you later. Does that make sense? So, you turned your phone off because you said you were scared.
Yeah, I turned it off. Then no, what's going on? I just turned it off.
What were you scared of?
Because I was just anything. I just turned it off.
Because this was before she died, right?
Before she died?
Yeah, you turned it off before you got to the park.
My phone. It was an iPhone.
It was the one you had your Gmail on. You turned it off after you texted Jayla at 11:05 and told her you guys were good. And you turned it off because then Jayla tried to call you multiple times and you didn't answer.
I just turned it off. I just turned it off. I was paranoid. I was just scared. I just don't know. Just turned it off.
Okay, because that is a little weird, I'm not gonna lie. That is a little weird, like I don't understand what you were scared of. You get what I'm saying?
Yeah, I understand.
If she, you know what I'm saying, if you had an agreement that this was gonna happen, I could understand that maybe. Like you had an agreement this was gonna go happen, you didn't really want to, but you were probably gonna help your friend out because you cared about her, blah, and you knew that this was about to go down and you guys had planned it. And you knew everything was you knew it was gonna happen, so you turned your phone off before to try to disconnect yourself from it. That would make sense, but if she was talking about killing herself, like, how did you know at that point to turn it off? Because you hadn't made it to the park yet. Did she tell you where you were going?
They just drove around.
So at 11:05, when you're at that corner, right before you're about to get to Yellow River, that's when you decide to turn it off? Because you hadn't gotten there yet.
Man, they just turned it off.
I mean, I'm right. It was before you got into the park, right?
I just turned it off.
Okay. I mean, you get where I'm coming from, right?
I do.
That's what I'm trying to understand it so I can later articulate it.
Okay, so I don't know. I just turned it off.
Okay.
That's what I'm trying to remember which phone I had because my Android I had to turn it off a couple times because it messed up a little bit and stuff like that. But
Yeah.
I'm trying to remember what you said my Gmail. It's been some time. I don't remember.
Okay. So, it was your Android because you text from the 865 number.
Okay.
And you were texting Jayla. I keep saying Jada, it's Jayla. You've been locked up since the Oscars, so that's why Jada's fresh in my mind. You know Will Smith slapped the shit out of you?
Yeah.
So that's why I'm thinking Jada. And like I said, I'm not accusing you, I'm trying to understand because these are gonna come up later, and it might come up later for you too, so I just want you to understand. That's usually what, him and I've been doing this a while, we haven't always been in homicide, we've worked in I've worked in robbery, special victims, he's worked in burglary, robbery, plus we've been on the road, and so we've investigated a lot of crimes. And usually what people do is they turn their phones off before they get to what's about to happen, so they can't be tracked because they know a crime is about to happen. Does that make sense? So that's what it's going to be perceived as, and I don't want to do that if that's not the case. I'm trying to fully understand where you're coming from on that. And do you have another way to word it, maybe?
So you're saying I'll turn my phone off?
Before you guys depart, yeah.
Before I depart?
In our experiences, say the three of us are gonna do like some armed robberies or something like that, a lot of times people will be like, all right, well, we're all gonna turn our phones off so nobody knows where we're going before we go do something. So was she like, hey, let's turn our phones off and go, walk?
I don't want to say she told me to turn my phone off, because I don't remember.
Okay.
Because I want to just say, so I was paranoid, it's been a minute, I don't remember.
Okay.
When I turned my phone off.
Yeah.
So she clearly told me to turn my phone off, I don't know, I just turned my phone off, I know I was paranoid, so I turned my phone off.
Okay.
So I wanted to say she told me to turn my phone off, but I'm not 100%
Right,
sure.
Yeah. Okay.
And she, like, we on the way there, she was telling me everything, everything, so I don't know.
Why didn't you call the police on the way there? I'm asking because this is gonna come up later. I'm just asking. People are gonna ask me, so.
I don't know, because we've been knowing that story, she don't never go through with it, I thought,
She just talks about doing it all the time.
yeah, and this time, man, things was gonna get like this.
Okay.
I want to raise my son. That's all I want to do. I just want to raise my son.
Another question, just to say we asked it, did you shoot her?
Mm-hmm.
Okay.
Why wouldn't you shoot her if she wanted to die?
Because I want to raise my son. That's murder. That is murder if I shoot her. I want to be here for I want to be here for jail.
No, I believe you. I just wanted to ask why, because it'll come up later. Nothing's working. I give up.
I'm sorry that I do all this, but the point, I just want to raise my son. All I want to do is raise my son. I don't want to be a statistic and be in and out of jail.
Yeah.
Because I know me, my dad was not here for me.
Yeah.
And I grew up in a certain way because my dad was not here for me. I don't want that for him. I want to be here for him. I want to raise him right. I want to make sure he's a good man, better than me. Make sure he don't do stupid things like not do the right thing. Like me, I messed up. I should have called the police.
Yeah.
But seeing her right there and all that, and I didn't know what to do. I didn't know what to do. She told me, go ahead, just go take the car. So that's all I had to in my mind. Take the car, take the gun, go ahead, go.
Did she still want you to shoot her when you guys were in the park? Was she still asking you to do it? Okay.
I didn't want to take the gun. I didn't want to touch the gun. Anything, but I just took the gun from her, and I was just telling her, just calm down, and I love you, and I dropped a bunch of love her, and he pushed her over and grabbed the gun and shot her straight.
Okay.
I'm a black man.
That means nothing to me. I just want to let you know. I want to let you know that means nothing to me.
Y'all, with
I get it.
one of them juries and all that, it's like, it's the world, I don't know. So,
Before we head out, is there anything else that you think we need to know?
Anything you can think of that might help me corroborate this? Because I want to corroborate it. Do you know what corroborate means? I want to find evidence to prove your story.
That's everything.
But I mean, you did tell Jayla's mom? Is that what's name?
Jayla?
Yeah.
I ain't tell her. She was saying.
You told her she was suicidal?
Mm-hmm. I didn't tell nobody anything. I was like, nobody anything. I just pray and hope that I don't have to, like, I don't know what I would do, like 30 days or whatever. I'll do whatever I do, but I don't want to be gone for 5, 10 years.
Yeah.
I want to, because I want to raise my son. I don't want to be in where the murderers or rapists. That's not me.
Yeah.
That's not me at all.
I know.
And I pray every day and just like tell God, I wish I did the right thing and just call the police. I wish I did the right thing and just, like, when I had to come up and just shot all the bullets out.
Yeah.
Like, I wish a lot of things. I pray for a lot of things that y'all really help me though.
I'm gonna try.
I mean, all we can do is take what you said and put it in a report.
So how it works, we're like fact finders. So when I say I'm gonna try, it means I'm gonna try to go find evidence to back your story. Because I wanna look into it. Because my job, I don't want, if someone's not guilty, I don't wanna lock them up. My idea is just to get all of the evidence and put it together.
Like, we're gonna go out, we're gonna try to find this lake, we got dive teams, we're gonna go dive in the water and, hope we find the gun that you said was there.
What else? Like,
I can't think of anything else right now, but are you open to talking to me again if I found, okay?
Just call me and everything, but I mean, like all the time I have to go to work. I have to
I know.
provide and everything.
But now can you stop avoiding me? I'll come meet you. I'll come meet you. I'll come meet you in the parking lot. I don't think they're gonna let me take it.
You don't know me to take it?
He has my number.
Okay, yeah, I just,
All right.
But it's just,
I'll come meet you on your lunch break. Whatever. I have a car. The county pays for it. Not your tax dollars because you live in a cab, but the Gwinnett County residents pay for me to go wherever I need to go.
please, just keep that in your mind. I just want to raise my son and do the best that I can for jail.
I understand.
I understand I'm mad for taking the car and all that stuff and all that, but that's honestly God the truth.
If you could talk to Tori's mom right now, what would you say?
I'm sorry that I didn't tell you earlier. I'm sorry that I should have told you that, that something happened to her. I'm sorry. And to be honest, Tori talks to me. Like she talks to me. She always talks to me. And the biggest issue was her mom. The biggest issue was like she felt more depressed because of her mom. And I mean, I can't say nothing to her mom. Like, 'cause I feel the same way Tori feels towards her mom. So, that's all I say to her is sorry. And I wish she could understand her daughter more, or she could understand her more, she probably would have been here. But that's it, really.
Okay.
Please just have that in your mind. I just want to
I
raise
will.
my son and be the best man I can. I'm not a murderer. I don't,
I'm curious, but I was asking you because, I have to go back and talk to her mom. I talk to her almost every single day. And it's been 8 months, and she's been going through it. Granted, her and Tori might not have gotten along, but, you love your son. I love my son. I'm a parent too. Even if we don't get along, you still have this love. Like, it's a piece of her. So she's been going through it.
I wish you could understand Tori. That's the biggest thing is money. And her mom, Tori didn't live with her mom one time. Her mom, Tori was doing better at her grandmother's house than she was at her mama's house. And when she forced her to come back to her mama's house, that's when everything was left. But I want to raise my son. All I want to do is raise my son and be the man I can be for jail, and get us a big house and everything like that, and go to the NFL and do everything I want to do, but I don't know, I told you this, honestly, I told you everything.
Okay.
And so going this case right here, from a jury standpoint, what would happen?
Oh, it's a long process after this. It's not, there's just so much that goes into it. I can't answer that. So for me, I'm gonna type everything up. I have to go meet with our district attorney, our district attorney's office, and then our liaison that works with us, and then go over everything as well as talk to my sergeant about things. That's why I said I can't give you an answer now. So based on those conversations, either charges will be taken or they won't be taken. If charges are taken, then, warrants will be placed for your arrest. You'll come to Gwinnett County Jail, you'll be appointed an attorney, then you'll start the process from there. So I don't know what charges, like I said, because I don't know what's going to happen.
Gwinnett County Jail, was that White Street?
It's a lot, actually.
Yeah, Bailey's
White
on.
Street?
No, Gwinnett.
No,
360.
you said where's that?
No, I'm saying White Street, like that's White Street?
No.
No, because I'm hearing Sandy Springs don't have a jail.
Yeah, you're Fulton County.
Fulton County, and Fulton County is what?
I think, isn't it DeKalb? Oh, I thought it was DeKalb or something. So DeKalb jail is not nice. Everyone, like, when I've arrested people before, when I tell them we're going to Gwinnett, they're like, hell yeah, as long as I don't go to DeKalb.
Yeah, they say Gwinnett, like,
Stopping at 1 hour, 10 minutes, 45 seconds. Detective Carter, you are, at this point, the lead detective on this case, correct?
I am.
Is your role to know each and every part of the case, including what was done by Sergeant Smith, other officers, the medical examiner, everybody and everything in the case?
It is.
Did you end your investigation right here at this point where you've gotten some admissions from the defendant?
I did not.
What did you continue doing after this interview?
I went back to review the evidence again and compare it to statements that he provided in his interview regards to her shooting herself, the way he explained it, and falling down. The way she was located didn't make sense based on statements he made. Excuse me. Well, in my head, it didn't make any sense because of the way she was located. Her braids, I believe, were 36 inches long, and none of them were underneath her. If somebody falls, the way he described it, the hair is gonna be, there's at least gonna be some hair under her. It's not gonna be like perfectly sprawled out behind her head. So it made sense in my head, but I wanted to just verify, so I did purchase a wig that had similar length braids, put it on one of the dummies, and we dropped it like a million times, and again, nothing similar to the scene where we found came out from that.
Is the way Tori's hair was laid out when she was found consistent with with the lady with long hair throwing her hair back before she lays down?
Yes.
When you interview a defendant, do you always tell him the truth?
No.
Do you use various and sundry interview techniques to get him to continue
I'm
talking?
just going to object as leading judge.
Repeat your question, Mr. Norris Lewis.
Do you use various and sundry interview techniques to get a defendant to continue talking?
I overrule the objection. I will allow it.
Yes.
Does that include agreeing with him?
Yes.
Does that include telling him you believe him?
Yes.
Can it include outright lying to him?
Yes.
After you determined that his version of events simply did not make sense and did not comport with the evidence, what was your next step?
I met with assistant district attorneys with our district attorney's office and presented the facts of the case to them because of the way the case was going. The way the medical examiner ruled her death, I wanted to put everything in front of them, explain the facts, explain the inconsistencies, and get their opinion on where they wanted me to go with this.
Ultimately, did you take warrants against the defendant?
I did.
What charges did you take warrants for?
Aggravated assault and felony murder.
And being the lead detective and knowing everything about the case, did you know anything about the vehicle that Tori had?
I I know that it was burned in Hidden Acres.
You know what kind of vehicle it was?
Yes, it was a 2012 light blue Nissan Versa.
Were you able to determine its approximate fair market value?
I looked it up on Kelley Blue Book, yes.
About what was that fair market value?
It was for a used vehicle that year. The range was $5,009 to $6,794.
Sorry, 5,009 to what?
$5,009 to $6,794.
Did you investigate the pond, lake, or body of water where the defendant told you that he had thrown the gun?
We did. Hall County dive team came out and assisted us with that, and they did dive, but they did not locate the firearm.
Now, at this point, we are in March of 2022, is that correct?
It was the end of March, I believe. I'm not sure if it was right into April yet.
And how many months after Tori was killed did we discover where to even look for the gun?
8, 9 months.
That's all the questions I have at this time.
Right, cross-examination.
Judge, can we take a break at this time, just 5 minutes?
Sure. All right, ladies and gentlemen, we'll just use this as our mid-morning break. So we will be in recess until 10:45, and then we will go until the lunch hour. Please leave your notepads and pens in your chair. Remember your precautionary instructions. And step down.
Thank you.
10:45, please.
5 minutes, Judge.
All right, Mr. Ford is back with the deputies, 10:45.
Thank you, Judge.
So that case downtown, with the multi-co-defendants, the 9 months, Bruce Harvey and a couple of the other defense attorneys refused.
All right, is the state ready for the jury?
Yes, sir.
Defense?
Thank you, Judge.
All right, let's bring in the jury. Cross-examination by the defense, please.
Thank you very much, Judge. Good morning, Detective Carter.
Good morning, Mr. Lewis.
How are you?
I'm good. How are you?
Good, good. I'm doing well. Let me start here with Tori's social media. Did you check on Tori Lang's social media?
On her Instagram and her Facebook.
Okay, and so that answers two other questions. She was active on Facebook and Instagram, is that right?
She had a Facebook account, but she did not appear to be active in it. She didn't appear to be actively using it, but she was using her Instagram account.
All right. And did you use her Instagram account to find out if she had any friends that might have any information concerning her death?
I did.
Were you able to get any names of any friends or interview anybody that she had been in contact with on Instagram?
I interviewed multiple people.
Did you interview Scoop?
No, he would never call me back.
Okay, he was active on Instagram, but you never interviewed Scoop, is that right?
That's correct.
All right. And what was his relationship to Tori Lang?
They were in a relationship, but he appeared to be involved with other individuals.
All right. Did you ever have any chance to speak to Marquasia Watson?
Yes.
What was her relationship to Tori Lang?
They were friends.
Do you recall how long they had been friends?
Years.
Were they friends both in real life and online?
Yes. Did you say Marquesa or Marquesa?
Is it Mark? I'm sure.
So there's a Quasia and a Marquesa, so I'm just
Okay.
making sure.
So we go with the surname Ms. Watson. Who was is that Marquasia Watson?
I thought it was Marquesa Brown, but I could be wrong.
Okay.
Yeah.
Okay, give me the two names. You think there's a Marquesa?
Yes.
Okay. And you think her last name is what?
I believe it's Brown.
Okay. And you had a chance to speak to her, is that right?
Multiple times, yes, sir.
She was a friend of Tori Lang's?
She was.
I may have the name wrong. Sometimes that happens. And they have been lifelong friends, is that right?
Yes.
And who's the other person you were thinking?
Quasia.
Quasia. And what's Quasia's last name?
I can't recall it this time, but it might be Watson. I just know when I tried to run the last name she gave me, I never could get a return.
Okay. And what was Quasia's relationship to Tori Lang?
They were also friends.
Also friends. The same length of time that Marquasia Brown was friends with her?
No.
I'm assuming that sometime you spoke to Dr. Terry, is that right?
I did.
Do you recall when that happened?
It was shortly after I took over the case because I had additional questions.
Okay, and my understanding is the other detective was on the case for about 6 weeks, is that right?
Yes, sir.
So somewhere around maybe the first week or second week in September, you took over the case, is that right?
It was whenever September 19th. It was that week of September 19th, 2021.
That's fine, September 19, 2021. You took over the case, and if I understood your answer correctly, shortly after that, you went and you spoke to Dr. Terry?
Yes, sir.
Did you review the medical reports before that time, or did you go speak to her first?
I reviewed the medical reports beforehand.
All right, then you go over and you talk to Dr. Terry, is that right?
Yes, sir.
Okay, and obviously the goal after you read the report, when you go talk to Dr. Terry, is to try to get some clarification on her thoughts, Dr. Terry's thoughts about whether this is a suicide, homicide, or closer to a suicide versus a homicide. Is that fair to say?
Yes, sir.
All right. You indicated to the jury a little bit ago that you videotaped some physical demonstrations after you bought a sort of mock dummy with long hair and dropped it in numerous different directions. Is that fair to say?
Yes, sir.
You were trying to determine how Tori may have fallen after she was shot. Is that correct?
Yes, sir.
And in fact, you also went out to Yellow River Park and dressed up in a certain way to try to see how Tori may have fallen after she was shot. Is that fair to say?
I don't believe we did falling because I didn't want to fall to the ground.
Okay.
But we did see if dragging and stuff like that.
Okay, and all of this was recorded. You're being on the scene where Tori was found and you dropping the doll, the life-size doll with the hair, all of this was recorded, is that right?
It was. The dropping of the doll was actually at our training center because it was the training dummy that they used.
Right.
They used, sorry.
Right, no, it's no problem. And all of that, if I understand you correctly, was done after you spoke to Austin on March 30th, 2022, is that right?
Yes, sir.
Okay, and Dr. Terry has come into court and testified that Tori was indisputably laying down with her facing up. Were you left with that impression? Were you left with the impression after talking to Dr. Terry that Dr. Terry's position was uncontested, Tori was laying on her back with her face towards the sky. Were you left with that impression in September of 2021?
After I met with her, I was not left with that impression. I believed, like she said, it was consistent with her being laying on the ground. At that time, everything was still new and it was still fresh. So I don't believe I asked any further questions like, is it possible she was standing? Is it possible this? Is it possible that? My questions with Dr. Terry when we were meeting were more or less in regards to the radius of the gunshot wound or the distance of the gunshot wound, questions about the possibility of it being like that. And I did ask her if she did fall, like, would there be blunt force trauma to her head? Like, would there have been injuries to her head? Stuff of that nature, just basically trying to get a better understanding of things.
And I love that last question because that, of course, as an investigator, made sense to you. If somebody shot and they fell backwards, when they hit the ground, there would have been some type of blunt force trauma to the head or back. Is that fair to say?
Yes, sir.
That's sort of your experience as a homicide detective, is that right?
You would think so, yes.
Sure. And when you put that question to Dr. Terry that way, hey, you know, if a person was shot and they fell backwards and they hit their head with their experienced blunt force trauma, did Dr. Terry say, listen, you don't need to worry about that because I'm telling you, the science says she was laying on her back with her face towards the sky. Did Dr. Terry tell you that?
No, she just answered my question directly and said that if someone falls to the ground, there's not necessarily a sign of blunt force trauma.
I like when you say answer your question directly because the jury's already seen Dr. Terry correct my grammar twice. So we know Dr. Terry's not the type of person that you're going to just bully around. If you say something crazy, she's going to turn right back around and tell you, you don't need to worry about that because this is how the body was. You don't find her, you don't find that she's the type of person that you can bully, do you? You being the detective, if you have a theory of the case and she has a theory of the case.
I'm going to object and ask that Mr. Lewis either ask a question or allow Detective Carter to answer the question that he did ask.
That's right. That's
Right, so that's sustained. This isn't your closing argument, Mr. Lawrence Lewis, so please ask a question while the witness is on the stand. Sustained.
Yes, Judge. You don't find that Dr. Terry, and you're dealing with Dr. Terry, is the type of person, if you have a different theory than her theory, that you can just bully her into your theory. You don't, that's not.
Absolutely not.
Right. So when you put to Dr. Terry, hey, if a person is shot, falls backwards, would they have some blunt force trauma to the head? She never told you at that time. You don't have to worry about that because I'm telling you, the science says she was laid out flat when she was shot in the head. She never told you that, did she?
No, I think she was just answering my question.
You requested info on Austin's cell phone after you were assigned on the case, is that right?
Yes, sir.
Okay. If I understood your testimony correctly yesterday, the cell tower triangulation showed that Austin was at his apartment for most of the time between 10 p.m. and 6 a.m. Is that correct? Do I have that right?
Some of the times in between there.
Okay. Did any cell tower ever put Austin inside of Yellow River Park?
No.
Okay. And I thought that you testified that Google put Austin somewhere on Annistown Road about 11:05 p.m. Do you recall testifying to that yesterday?
Yes, sir.
Okay. Where did Google put Austin on Annistown Road at 11:05 p.m.? Annistown and what?
North Deshaun Road. It was at right at the corner.
Okay, good. There's a little gas station there.
Yes, sir.
Okay, I got you. Okay. And did Google tell you where Austin stopped when he stopped moving quickly, which led you to believe that he might be in the car? Did Google tell you where Austin stopped?
He ultimately went back to his apartment.
Okay, and so is that where Google told you that he stopped?
So it did continue showing movement. So he was at his apartment after the vehicle, and then you can see him leaving afterwards. And then it continued to move after that.
Were you left with the impression that the vehicle stopped at any particular place by following the Google information on Austin's phone?
It appeared to be in the area of his apartment,
Okay, and his apartment is located on 124, is that right?
off of one, yes, sir.
Off of 124, just across the street. I think the church down there is, what's the name of the church down there?
I'm not sure.
I have it somewhere, but that's fine. We'll get back to that. 124, just south of Rockbridge Road, is that right?
Yes, sir.
Okay. Stronghold Christian Church. Do you recall seeing the large church down there, Stronghold Christian Church, across from Austin Ford's apartment complex?
There were buildings around. I didn't take note to them or anything.
It's fair to say you can see Austin Ford's apartment complex as you travel south on 124. Is that fair to say?
Yes, sir.
Okay. And I think your testimony yesterday was Google gives you more accurate information than the tower triangulation. Is that fair to say?
Yes, sir.
Okay, and that's why you requested the geofence at Yellow River Park?
I requested the geofence at Yellow River Park prior to thinking of Austin as a suspect. That was an attempt to figure out who may have been there or other witnesses that may have been there.
All right. Did the data give you any devices inside that geofence at Yellow River Park?
No, they were just traveling on Juhan Road, passing the park.
Okay, and when you say they, you mean the cell data that you received, is that right?
The geofence data.
Got you. Tori's cell phone, where was Tori's cell phone at midnight from the 27th into the 28th of July 2021? Where was her cell phone?
It was with her mother, Tori Lang.
Okay, and did you ever find out if that was sort of normal, that Tori would just sort of leave her phone like that?
I don't believe it was normal, but the reason was they were, I believe, transferring services. They were going, I believe, from Verizon to Xfinity, I think.
Okay. So Tori's cell phone, was it on the entire time?
But yes, it was.
So it was on, but she had left it behind with her mother, is that right?
Do you mean turned on or service active on?
I'm just,
I apologize. I'm just trying to make sure I'm right.
it's no problem. I'm trying to figure out how anybody in 2021 leaves their house without their cell phone.
Yeah.
But I understand your testimony to be Tori left her home without her cell phone because something was going on with her cell phone. Is that right?
Yes, sir.
Okay, that's what I want to understand. When was the last time Tori appeared to have used her cell phone?
That morning.
Was she making calls?
She received a call from a phone number registered to Jayla Summers.
Okay, do you know to whom Tori made her last call?
She didn't make a call. She received a call and answered it.
Okay, do you recall if you can recall, do you know who Tori's last text was?
No.
Do you know if the texting and the call that she received were about the same time?
Yes, sir.
The first time you spoke to Austin on the phone, was that August 25th, 2021?
No, I didn't have the case yet. Are you referring to October 25th?
Yes, that's what I have here, October 25th.
Oh, I thought you said August. I apologize.
No, that's me. I asked, August 25th, 2021. You didn't have the case yet.
No, sir.
When was the first time you spoke to Austin on the phone?
October 25th, 2021.
October 25th. So the conversation that we listened to yesterday where Austin talked to you a little over an hour, that occurred on October 25th, 2021. Is that right?
Yes, sir.
Okay. In that conversation, which we listened to yesterday, Austin indicated that he thought Scoop was a bad influence on Tori.
Yes, sir.
You heard Austin say something about perks, beans, and Xanax, right? That you heard Austin say that. Is that right?
Yes, sir.
Okay, I don't know if the jury knows. Perks is Percocet. Is that right?
Yes, sir.
Okay, and beans is ecstasy.
Yes, sir.
Okay, I got that right. And Xanax is Xanax. Is that right?
Yes, sir.
Okay, and Austin at the time thought that Tori's boyfriend, Scoop, was a bad influence because Scoop was introducing Tori to these drugs. Is that right?
Yes, sir.
Okay. October 29th, I'm sorry, March 29th, 2022 was the first time you met Austin face-to-face?
Yes, sir.
And that was there in the jail at Clayton County, is that right?
Yes, sir.
Okay. When you met with Austin, you knew at that time that he was under 21, is that right?
I did.
Okay, and part of that was the fact that he had been arrested in Clayton for a gun after the police were called, after him and his girlfriend got into an argument about his ability to take care or not take care of her financially. Is that right?
Yes, sir.
Okay. And I think you asked him about that. Why not just go to a pawn shop? And then, of course, you reminded yourself that he was under 21. Is that right?
Yes, sir.
Tori and Austin were about the same age. Is that right?
Yes, sir.
I understood that they had been friends for a while. Did you understand that they had been going to school together during the time that they were friends?
Yes, sir.
Do you know if they were in the same class, like same 7th grade, 10th grade together?
I believe they met in 9th grade. I don't know if they had classes together.
Okay. Austin told you when you spoke to him down in Clayton County that he was trying to take care of his girlfriend and her baby, which was not his child. Is that right?
Yes, sir.
Okay. And did you think that Austin, when you were calling Austin prior to meeting with him on March 31st, March 29, 2022, did you think that Austin was sort of avoiding you, or just life was just beating him up?
In my opinion, I felt like he was avoiding me.
Okay. Because you had given him sort of every opportunity to meet with you. Is that fair to say?
Yes.
You had offered to come to him. Is that right?
Yes, sir.
But he was bouncing a little bit. Is that fair to say?
Yes, sir.
He was never really in one place. He didn't seem to be stable. Is that fair to say?
Yes, sir.
Okay. Austin, during the recorded interview, indicated that Tori shot herself. Is that right?
Yes, sir.
He repeatedly said he never shot her. Is that right?
Yes, sir.
And Austin said to you during the interview, I thought he said this, that he never saw her fall. You recall him saying that? Never seen her fall.
He told me that she fell. I believe he said something that he didn't look at her afterwards, something to that effect.
Okay. Did Austin indicate to you whether or not he had to take the gun out of her hand or if the gun fell after she shot herself?
He said the gun fell out of her hand.
If I understood your testimony correctly, you had to call out the Hall County dive team?
Yes, sir.
Hall County.
Yes, sir.
I thought it may have been Rockdale for a second. Hall County, which is a county north of Gwinnett.
Yes, sir.
Okay, Austin told you that he had dumped the gun in Hall County?
No, sir.
How did you get to Hall County?
We just have a relationship with our dive team and we use them often.
Okay. So Hall's dive team, does Gwinnett have a dive team?
No.
That may be the reason. So Hall's dive team comes to DeKalb.
Yes, sir.
There we go. I got you now. And which body of water did they search in DeKalb?
It was a private residence off of, I believe, Ashbury Road, or Ashbury Lane, I believe. It was the speed bump road that he referred to in his interview because it legitimately had multiple speed bumps.
I got you. And about how far was that body of water from Yellow River Park as the crow flies?
2.5, 3 miles.
Okay. And was it about the same distance from Austin's apartment?
Yellow River Park or the pond?
The pond.
No, it was like maybe 1/4 mile,
Okay.
if that.
So the body of water was closer to Austin's home than it was to Yellow River Park. Is that right?
Yes, sir.
And Austin's residence is probably only about 5 minutes away from the park. Is that fair to say?
If you're driving,
Yeah, driving.
5 to 10 minutes, maybe 15.
Yeah, you come out of his apartment, make a left on 124, you go to the second light after Rockbridge, make a left, and you're almost right there on top of the park. Is that fair to say?
Yes, if you take that route.
Okay. Is there a faster route?
I don't think there's a faster route, but the way that when the Google records came back on, there's another way you can take a left off Juhan and out of the front. So there's two entrances, like on Juhan.
Yes.
You can take a left out there, go down Annistown, and kind of go back the way that the records show him going there. And that would put him on Rockbridge Road, and that's when his phone had turned back on. Well, started pinging again.
Yes, if in fact you leave if in fact you leave the parking area of Yellow River Park near where Tori's body is found, you can exit Juhan Road onto Annistown Road. Is that right?
Yes, sir.
Okay, we got that. No gun was ever found by the Hall County Dive Team, was it?
No, sir.
Okay. Austin's apartment, it's about 5 miles from Stevenson High School. Do you know where Stevenson High School is?
I do have an idea of where it is, yes.
Is his apartment about 5 miles from Stevenson High School?
I don't know for certain, but yeah, that seems about right.
Okay. And the burnt, I'm gonna call it burnt out vehicle. The burnt out vehicle is less than half a mile away from Stevenson High School. Is that right?
Yes, sir.
Okay. The prosecutor asked you a question about speaking with some folks at the DA's office. Do you testified that you spoke to some folks at the DA's office before taking any arrest warrants? Is that right?
Yes, sir.
Did you speak? Who did you speak to?
It was a group of people. I know Sabrina was in there, Sabrina Nazim, Daryl Manns, I believe the investigator Whaley. There was multiple people in there.
Okay, so you were speaking to the top brass in the DA's office at the time when you were speaking to them. Is that fair to say?
Yes, sir.
Okay. And did you speak once or more than once? Do you recall that?
I communicated with them throughout my investigation, Sabrina in particular, but I only met with them in person one time.
I got you.
Prior to taking the warrants.
I got you. What date was that? What date did that conversation take place? Do you recall that?
It was between March 29th and April 15th.
April 15th. Does that represent the date you took the warrants?
Yes, sir.
April 15th, 2022. Is that right?
Yes, sir.
Okay.
And I believe the meeting was probably either the day before or actually the day of April 15th.
Okay, and then sort of after speaking to the DA's office, you made the decision to take the warrant for felony murder and for aggravated assault. Is that right?
Yes, sir.
Okay, so when this indictment that the jury will have out with them comes back,
Waiting for the question before I did.
you didn't take a warrant for voluntary manslaughter, did you?
Objection, Your Honor, relevance.
What's the legal basis for just relevance? I mean, it is a charge on the indictment, so why would it not be relevant?
Whether or not Detective Carter took a warrant for it's not relevant.
I'm going to overrule it. She's on cross-examination. I'll allow it.
You didn't take any warrant for voluntary manslaughter, is that right?
That's correct.
Okay, and you didn't take any warrants for any theft by taking of any gun or theft by taking of a vehicle, is that right?
That's correct.
Okay. But you did testify at the grand jury that returned the indictment, is that right?
Yes, sir.
All right. I don't have any further questions. Thank you very much, Judge.
Redirect.
Does the fact that you did not take a warrant for theft by taking, for example, mean that somehow a theft by taking did not happen?
Judge, I think that's up to the jury. I don't think that's up to her. I'm going to object to that question. That's for the jury.
Listen, you opened the door about whether or not warrants were taken versus what was indicted, so I'm going to allow Mr. Norris Lewis to follow up on redirect.
Yes, Judge.
Can you repeat the question? I'm sorry.
So does the fact that you did not take a warrant for theft by taking mean that a theft by taking did not happen?
No, it's actually pretty common for us not to take all of the warrants that may be according to, fit to the case for you guys.
And so, which kind of answers my next question, which is, do you take every warrant for every single offense in every single case that you have?
No.
When you met with Dr. Terry were you asking specific questions that you had about the case?
Yes, I was kind of brainstorming because I was still coming into the case and trying to think of scenarios.
Did you ask specific questions about the positioning of the body when Tori was shot?
Yes.
What do you recall what questions you asked?
We were discussing in regards to her hands.
Okay, so the questions you had more to do with the position of her hands,
Yes.
less so with the position of her body as a whole.
Yes.
And when you investigate something, I mean, I guess the art of it, or the act of investigating, is trying to find out about something. Do you explore avenues that don't always pan out?
Yes.
Do you sometimes talk to people who have no information?
Yes.
Do you sometimes look down a path and find that this is not the path we need to be on?
Yes.
Is that the nature of investigation?
Yes.
That's all the questions I have. Thank you.
Recrossed.
Testify, you normally don't take every warrant that you can, is that right?
Yes, sir.
All right. And the prosecutor's office ultimately has the final say on what charges go on the indictment. Is that fair to say?
Yes, sir.
But you conferred with them before you ever took any warrants, isn't that right?
Yes, sir.
Right. No further questions?
We redirect.
No, Your Honor.
All right, is Detective Carter excused by both sides?
She is, Your Honor.
No objection, Judge.
All right, Detective Carter, you can step down. You're excused from any further appearance.
Thank you, Your Honor.
Call your next witness.
Your Honor, I believe I have tendered, and the following exhibits have been tendered and admitted. 1 through 43, 45 through 58, 60 through 63, 15 sub A, B, C, D, E, F, G, and H.
I don't know, but the record will reflect what exhibits have been tendered.
Of those exhibits, if they have not been tendered and admitted, I tender those exhibits. I believe all have been admitted, but with that, the state rests.
All right, members of the jury, the state has rested, which means they have closed their portion of the evidence in the case. At this point, I'm required to take up some legal issues with the attorneys arising out of the state resting at this point. So let me have you just take a recess. They can be at ease for probably at least 15 minutes, and then I'll have an update on scheduling, but we are on track as planned to get this case to you shortly. So let me just plan for a 15-minute recess with an update on scheduling. Leave your notepads and pens here, and remember your precautionary instructions, please. Give me just a moment. Give me just a moment to have Ms. Wofford step in for me, please. While I'm waiting for Ms. Wofford to come in, let me inquire of Mr. Lawrence Lewis and Mr. Austin Ford, but Mr. Lawrence Lewis on his behalf. Did you have any further discussion, or do you need to have any further discussion with Mr. Ford on his decision to testify or not testify?
I apologize for going out of order, Judge. Respectfully, I don't have any motion for directed verdict. I'll put that on the record.
Okay, well, all right, I was going to ask Ms. Wofford to come in for that, but
Oh, sorry.
that's fine.
That's fine. So I want to make that clear. Judge, I don't have it, I did not speak to Mr. Austin Ford any further. I don't know that anything about his position has changed, so I don't have any objection to the court inquiring of Mr. Austin Ford directly if he wants to speak to me some more about that particular issue and whether or not he's going to be on the stand. or if he's already made a decision that he's not getting, that he's going to maintain his position, that he's not going to get on the stand.
So let me inquire of you before I touch on that issue again. In the event that Mr. Ford maintains his earlier position to not testify, do you then intend to rest your case?
I do.
All right. Mr. Ford, do you recall yesterday that I went over your rights and your choice as to whether or not you testify or not testify during your trial? Do you want me to go over those rights with you again today? All right, I will do so at this time. Mr. Ford, do you understand that you have a right to testify, and if you want to testify, that no one can prevent you from doing so? Do you understand that no one can make or compel you to testify? That is, do you understand that you have a right to not testify if you do not wish to do so? Do you understand that not your lawyer, Lawrence Lewis, but you personally are the only one who decides whether you will testify or not testify? Do you understand that if you choose to not testify, then upon a request of your lawyer or by you, I will instruct the jury that your decision to not testify cannot be used against you? Do you understand that if you choose to testify, that you will both be questioned by your attorney and cross-examined by the assistant district attorney? Having had these rights explained to you, do you want to testify or not testify?
Not testify.
Have you understood all of the rights as I have explained them to you?
Yes, ma'am.
And is your decision to not testify your decision?
Yes.
Have you had enough time to talk with your lawyer about that decision?
Yes.
Do you need any additional time to speak with your lawyer before making that decision final? All right. Having found again that Mr. Ford has been advised of his rights regarding testifying or not testifying, finding that he understands those rights, I find that he has made a voluntary election to not testify with a complete understanding of those rights. With that being said, I'd ask Ms. Wofford to step in for the motion for directed verdict, but as I understand it, no motion for directed verdict will be made by the defense. Is that correct?
That's correct.
All right, so now that the evidence is closed on both sides, when I bring the jury back in, I will allow Mr. Lawrence Lewis to rest on behalf of the defense, but I want to take these 15 minutes to go over the request to charge so that we can finalize those over the lunch recess. If everyone can pull out their request to charge that were provided this morning, as well as the proposed verdict form. And did I give one to the court reporter? Yes, okay. All right, so I'm just going to go over the areas that needed to be revisited after the preliminary charge conference that was held last night. So we are on the bottom of page 2, which is 1.32.10, the defendant's choice not to testify. Now that that decision is final, do you wish for me to give that charge? Mr. Lawrence Lewis.
I do, thank you, Judge.
All right, and bear with me because I'm going to try to clean this up on the computer as we go. Give me just a moment. All right, so that is the pattern charge, 1.32.10, and I will give that in its entirety. All right, and then that will take us to the bottom of page 3, 1.32.23, after exercising Miranda rights and reinitiating conversation. I believe the red portion is no longer applicable. That would relate to whether or not Mr. Ford took the witness stand.
Agreed, Judge.
The state want to respond?
I actually don't believe any of it. necessary. The defendant did not at any point exercise his Miranda rights. He never requested an attorney. He did not exercise his right to remain silent. He simply talked the way he had.
I understand that was your position last night, but that is a determination for the jury to determine whether or not any of those rights were invoked or not. So I will give the pattern charge, but strike the red language. All right, then that takes us to the top of page 4. Again, that one sentence at the top of page 4 would no longer apply since Mr. Ford has elected not to testify. So I will strike that red sentence. Anybody want to weigh in on that?
No, thank you, Judge.
All right, then 1.34.00 was a pattern charge on limiting instructions, but it did not really fit the evidence in this case, so I have crafted my own language. So this is the court's instruction or a version of it that was given during trial. Let me have each of you, well, let me strike out the second paragraph that starts with additionally. That will be struck in its entirety because that relates to redacted evidence, which we did not have. So it would just be that first red paragraph. If you all will review that and tell me if there are any exceptions.
Let them stay, Your Honor.
None, thank you, Judge.
All right, so that's what I will give. And then we are on the bottom of page 5. We were revisiting good character of the defendant, and no information, no evidence was presented as to that, so I will strike that in its entirety.
Yes, Judge.
Any objection from the state?
No, Your Honor.
All right, so that will be struck in its entirety. All right, on the middle of page 6, we have no one requested, but we also have no evidence of accident, 1.40, 1.30. So I intend to strike that in its entirety. Any objection?
No, Your Honor.
No, Judge.
All right, and then that brings us to, all right, the top of page 8, I just had a bench note to address with the issue of felony murder and provocation, but I'm just going to remove that bench note unless anybody wants to be heard. That was just for me to think about as these were being prepared.
I have no objection, Judge.
All right, and give me just a moment. And not hearing anything from the state.
I just didn't think I needed to weigh in on whether or not the court was going to read the bench note.
No, it wasn't for me to read the bench note. It was whether or not I needed to address anything that was outlined in the bench note. But
No, you did not.
okay. All right, then that takes us to the bottom of page 8. And I have crafted, let's see, 2.64.43 as well as 2.64.44 to make the distinction between the two theft charges, one that does require a finding of value and one that does not. So please read both of those and let me know if there are any exceptions. I think I'm going to change just the very last sentence to say, but value does not have to be proven by the state beyond a reasonable doubt for the item alleged to have been taken in count 6 of the indictment, the firearm. Instead of just, but does not have to be proven, but value does not have to be proven.
I got it.
Any exceptions from the state?
No, Your Honor.
Any exceptions from the defense?
I don't have any exceptions to what the court's suggesting or to the two paragraphs that we're reading here, 2.64.43.
All right, then let me convert that over to be given as written. A moment. All right, that takes us then to some defense charges, nothing affirmative defense.
I'm going to withdraw that, Judge.
All right, so 3.00.00 will be deleted. Then that gets us to the series of justification charges.
I'm going to withdraw. You didn't, on this one, you didn't necessarily write D16 or D17, but I'm going to withdraw justification, and use of force in defense of self or others, reasonable belief explained, and no duty to retreat. Everything in red, I'm going to be withdrawing, Judge.
All right, any exceptions from the state?
No, Your Honor.
All right, so all of those will be deleted in their entirety. And I believe that's it. So does anybody want to take a moment to just read through that one last time before I bring in the jury? See if there's anything else that anyone wants to note on the record. Otherwise, with the changes that we discussed, that will be, well, before you do that, let's go over the verdict form. So on the verdict form, there's nothing unusual or unique. Counts. One gives the option of guilty or not guilty. 2, guilty or not guilty. 3, guilty or not guilty. When we get to count 4 and 5, I've just delineated that count 4 is possession of a firearm during the commission of a felony, that felony being murder, giving the option of guilty or not guilty. Count 5 is the possession of a firearm during the commission of the felony of aggravated assault, giving the option for guilty or not guilty. On count 6 and 7, the theft charges, I've identified them as count 6 is the firearm, which is guilty or not guilty. Count 7 is the theft by taking of the vehicle. It is indicted for a vehicle with a value of $5,000 or more. So they have the option of guilty of $5,000 or more, or guilty of the lesser offense if they do not believe the value of a value between $1,500 and 1 cent, but less than $5,000, or guilty of $1,500 or less, or not guilty. So, I mean, the jury has to make a finding as to value based on the evidence. So these are the increments that are provided. And depending on the evidence, they will have to say not only guilty or not guilty, but at what value level. Anybody have any exception to that?
No, Your Honor.
No, Judge.
All right, and then count 8, the concealing, just gives the option of guilty or not guilty.
Judge, on the indictment, it reads tampering with evidence.
Not on my indictment.
Oh,
Is that 00981-3?
okay, that's just on the lead sheet then.
Yes, no, I'm looking at the indictment where
Count 8.
issue was joined. Count 8 says concealing death of another.
Oh, okay. I may have it. Oh.
Do you want to look at it to satisfy yourself? This is the indictment where issue was joined.
It's the re-indictment. Got you, Judge. Thank you.
Yep. All right, no issues with the verdict form from the state,
No, Your Honor.
from the defense?
No, thank you, Judge.
All right, take one last read through if you want of the charge with the omissions, and I think I've made all of the deletions, Lisa, so if they say good, I'm gonna send it to you for copies. Okay. Let me just check spacing. And then, Mr. Umberg, I'm going to keep them all together for lunch today and pick up their lunch. And if you will be very mindful of making sure that only jurors make it into the juror lunchroom. Okay, so just keep your eye on our jurors and their badges, because we had an incident yesterday. Pausing to wait for each side to let me know that they're satisfied with the final version, deleting and amending anything that we've just discussed.
The state's satisfied, Your Honor.
All right, then give me just a moment. Then what I'm doing my last read through for spacing, and what I would intend to do in just a moment is to bring the jurors back in to allow the defense to rest. I will send them to lunch, and we will do closing arguments right after the lunch hour.
Yes, Your Honor, that's satisfactory.
All right. All right, I'm sending it to you now. Does either side wish me to email the court's charges to them?
No, Your Honor, it's not necessary.
All right, let's bring in the jury. And you can be excused. Yes, I just emailed you. So
Just 12 copies for the jury, or 14.
And me and Christine. 13, 14,
Well, I know how many
15, yeah. 12 for them and then all of us. And you don't need to make the verdict form is final. Would you just do a check through and make sure everything's spacing is good before? All right, thank you. Having rested its case, I will turn to Lawrence Lewis. If you will please call your first witness.
Judge, respectfully, on behalf of Mr. Austin Ford, the defense rests.
All right, members of the jury, the defense has rested their case. Any rebuttal evidence from the state?
None, Your Honor.
All right, ladies and gentlemen, the evidence is closed for both sides. Due to the hour, we are prepared to move forward with closing arguments, but the closing arguments in charge of the court on the law will be fairly lengthy, so I'm going to give you your lunch break at this time. When you come back from lunch, we will begin closing arguments and instruction from the court on the law, which will allow you to begin your deliberations. Once the case is turned over to you for your deliberations, we will be on your schedule. So that means you determine when and if you take breaks, how long you take breaks, and how long you want to stay to deliberate. So we will be on your schedule. You will let us know that. I'm going to keep everybody together for lunch today, and the court will pick up your lunch. Let's be in recess for lunch until 1 o'clock. So please be complete with lunch at 1 o'clock, at which time we will be ready to present closing arguments and the law to you so that you can begin your deliberations. Please remember your precautionary instructions over the lunch break. All right, anything from the state before we recess for lunch?
No, Your Honor.
From the defense?
No, Judge, thank you.
All right, we'll be ready for closing arguments at 1 o'clock. Thank you. Mr. Ford's back with the deputies.
first needed the court to be aware before I...
When did it come?
All right, thank you. Let me give these to you right now, Mr. Umber. That's going to be the 12 copies of the jury charges. I'll give you the verdict later.
You want these handed out when you read the charge, or just?
No. Just hold it off to the side. When you take the evidence into the jury room, that will go with it. All right, we have everybody ready?
We do, Your Honor.
All right, let's bring out Mr. Ford, please. Going back on the record in the state of Georgia versus Austin, Tybee Ford, 23B00981-3. Everybody, including Mr. Ford, is present. Is the state ready for the jury?
It's ready.
The defense?
Yes, Judge.
All right, let's bring in the jury. Everyone, please check your phones. Members of the jury, the evidence having been closed for both sides, we will now move into the next phase of the jury trial process. which will be closing arguments or summation from the attorneys. I remind you that what the attorneys say in closing argument is not evidence. The evidence comes from the witness stand and from the documents and exhibits that have been admitted for your consideration. All right, do we have a closing argument? Well, let me ask the state, do you intend to give an initial and a concluding argument?
I do, Your Honor.
All right, then we will hear from you first, then Mr. Norris Lewis on behalf of the state.
The other Mr. Lewis, in his opening argument, spent a very long time calling this case weird, calling the indictment weird. Yes, this case is unusual, inasmuch as murders are usual things. It is unusual for two best friends to go in the park, for one to leave and the other to stay there with a gunshot wound to the head. It is unusual for one of those best friends to take the gun away from the scene of what he calls a suicide and throw it in a pond somewhere in DeKalb County. It is unusual for one of those best friends to drive that car away, to drive the other best friend's car away, and it turned up burned to the frame in a nature preserve in DeKalb County. It's unusual for that best friend to then lie to his best friend's mother on the day where she's missing, where she's wondering where her child has gone. And he's going to say, I don't know where she is. When he knows full well he left her dead in Yellow River Park. It is unusual for him to then, as now a grieving best friend who, at least the way he portrays it, is that I just lost my best friend to suicide. For him to skip the vigil at the scene. Oh, unless he's not ready to go back to the scene where he shot her. It's unusual for him to continue attending her funeral, calling her mother, talking to her mother, hugging her mother, knowing exactly what happened and what he did, what he had to have done in Yellow River Park. It's unusual for him to carry these lies forward and to tell more lies and lie after lie after lie to Gwinnett County investigators for 8 full months. It's unusual for that best friend to, when he's finally coming clean, not coming clean because his conscience got the best of him, he just wanted to tell the truth now. No. He's coming clean because he got caught in his lies, because his phone told on him, because we know where he was. We know when he turned his phone off, we know when he turned it back on. We can see that he went someplace that he could not have walked to. He finally came clean, and he tells a story that just clearly does not match the physical evidence. So yes, this case is unusual, and it's going to lead to unusual things, unusual indictments, and unusual testimony. Your Honor, I'll reserve the rest of my time to conclude.
All right, thank you. Do we have a closing argument on behalf of the defense, Lawrence Lewis?
As I come to the end of my legal career, I find myself often thinking about the beginning of my academic career. And it's sometimes unusual because I don't have all the facts from high school, but I always have two salient features anytime I think back to high school. The first thing I remember throughout all of high school and college is I actually believed that if I studied hard enough, I could understand people. If I really did my history lessons and sociology and religion, and I studied English literature, I would be able to understand why people do what they do. I don't know if that was naivete or hubris, but I believed that right up until the time that I saw the proliferation of cell phones. And that's when I knew, checkmate. There's no way in the world I'm ever going to be able to figure out why people do what they do. The second thing I'm always thinking about is this sort of low-grade anxiety and I think probably all teenagers have it. You're not quite grown. What's my life going to be? What type of man am I going to be? Am I going to be able to find a partner that'll sort of appreciate my little idiosyncrasies? And I call it a low-grade anxiety because that's now part of the culture, part of the American culture. Mental health is a part of the American conversation. And nothing about my anxiety caused any interference with my schooling, nothing about what I felt impacted my daily life. I didn't need to take any medication. Of course, you know I went to school in the early 80s. The early 80s. It was very simple then. There was no internet, and I think home box office, HBO, was the only thing that was hot in the street at that time. And inside of my 80s bubble, suicide was just a word, like socialism, some type of esoteric concept. It wasn't anything real. It didn't touch me. I didn't know anybody that had committed suicide. I didn't know anything about suicide. Of course, this was before I studied Sigmund Freud. This was before I read On Suicide by French sociologist Durkheim. This was before I studied Jean Piaget. This was before I read Marx. So, I mean, I was young. I was sort of clueless. Suicide, we know now, is a national epidemic. We know that now. We know that now. Mental health dominates the cultural dialogue. And we also know that young people are constantly being bombarded on the internet and social media with all sorts of images of what they should be, all sorts of anxiety-producing images. We know that now. A great deal has changed in the 40 years for me since high school. A lot has changed for me, a lot has changed for the society. And even in the almost 3 decades that I've been practicing law, a lot of things have changed. I never would have dreamed when I was a young prosecutor in Philadelphia that a prosecutor would depend 100% on a homicide conviction on the fact that the defendant told a lie. I wasn't there. It doesn't really matter how many lies fall from that first lie. I wasn't there. I told you that in the opening that he lied. But I never would have dreamed as a young prosecutor that I would be here some almost 25, 30 years later, and the entire case would rest on my clients telling a story. And of course, that's compounded and made more ironic by the fact that 85% of American culture is on the internet lying, pretending to be something that they're not, pretending to have things that they don't have. So now, honesty determines if you're guilty of murder or not. Not evidence, honesty. So, as my father loved to say, a liar will do anything. Let's be honest now. Let's talk honestly. Let's do it. We all understand the world that challenged Tori Lang as a 5'10", 237-pound female black teenager. We all understand the challenges that she faced. Between May of 2020, when she graduated, and July of the following year, that 14 months, we were under COVID restrictions. What did that mean? I remember that because I had to walk a quarter mile in Wade Walker to get to the baseball field to train the boys because the police had cut off the part of the park where all the young people were gathering. They were so tired of being cooped up in the house after 90 days, they would have these spring up parties and they would take over the park. And DeKalb County came and closed certain sections of the park. So I had to park near the tennis courts at Wade Walker and walk a quarter mile with all the baseball equipment and the boys because young people were going crazy being at the house. During that time, we know that Tori was on Instagram. Let's be honest now. Let's be honest. The only value a woman has on Instagram is her face and her figure. Let's be honest, if we're going to be honest. We know Tori's feeling that pressure because we have the testimony of the witness that told you what Tori is taking diet medication, prescription diet medication. She's feeling the pressure of being on Instagram. Let's be honest. Let's be honest. Of course, like any normal teenager, she's bucking up against her parents because she wants to be an adult and is not yet ready to be an adult, and half of the world is closed. DeKalb County's closed. She can't do it. She doesn't have the economic resources to do ultimately what she wants to do. And we know she's suffering from some type of depression, emotional fragility, whatever you want to call it. Her mother told you freshman year she was hospitalized. When the officer, the first assigned officer, went to see mom, what did they tell him? She was suicidal, Detective Smith. Mother told Detective Smith she was suicidal. Marquise Marchese, not Austin Ford, also told him. So he had two separate people who were intimately connected to Tori telling him, the lead investigator, Tori was suicidal. So we know exactly how Tori comes to be at Yellow River with her mother's gun laying on her back at night looking up at the tree. We know exactly how she came to be there. So the question is, do we need somebody to blame for that? That's the real question. Do we need somebody to blame for that? I want you, when you come here, when you go in the back and you deliberate, I want you to bring your common sense and experience. But you know what I want you to leave out there? I want you to leave this new American zeitgeist. I want you to leave it out there. What am I talking about? This anytime I don't get what I want, anytime my feelings are hurt, I'm a victim. And I need somebody to blame. I need some oppressor. Leave that out there. Nobody grew up with that. That's new. That's new COVID, post-COVID thinking. We don't need that. Leave that paradigm out there. People get hurt all the time. There are car accidents all the time. You're not a victim every 2 seconds. Leave that out there. All during voir dire, you heard the prosecutor asking you the same question over, what would you do? What would you do if somebody told you it was suicide? What would you do? What would you do? I would do almost anything. And he's setting it up for you. He's setting it up. Somehow it's Austin Ford's fault because he didn't do enough. It's somehow Austin Ford's fault because he ultimately didn't do enough. So I guess that's it then. We do need somebody to blame. I guess that's it. Maybe we're answering that question. We need somebody to blame for Tori being in Yellow River Park with her mother's gun laying on her back at night, looking up in the trees. So we're going to pick Austin. Austin? Austin Ford? Austin didn't create the internet. Austin didn't invent the cell phone. Austin doesn't work for Apple. He's not on the marketing team that's got the children addicted to the cell phone. Austin's not setting the standard for women on social media. Austin's not responsible for that. Austin didn't bring us COVID and the mental health problems that came with COVID. Austin didn't do that. We know Austin's not the reason that the suicide rate has been going up since '02. That's not Austin. That's not Austin. It's not Austin's fault that people on social media have anxiety when they're on social media, and when they try to get off social media, they're anxious. That's not Austin's fault. But we gotta have somebody to blame for Tori being there. So, let's be honest, if honesty is paramount. Let's be honest. Austin's not the reason. Thursday afternoon, so you're going to have the case about 24 hours earlier than I expected you to have the case. The case lasted basically less than 2 days. Wasn't a long case. What are the undisputed facts? Undisputed. Tori took the gun from her mother's residence. That's undisputed. Tori drove her vehicle to Yellow River Park. Her vehicle to Yellow River Park. My client didn't pick her up. She drove her vehicle to Yellow River Park. Tori was experiencing some type of mental distress. Detective Smith tells us that when he tells us, I was assigned, I went out to talk to the people that knew her the best, and they said she was suicidal. She was suicidal. That's what we know, undisputed. Tori laid down under a tree voluntarily. That's undisputed. How do we know that? We know that because there are no defensive wounds, no scrapings were done under the fingernails based on the medical examiner's experience. She looked at her. Yes, they did a rape kit. There's no sex, let alone sexual assault. She's dressed the same way in the park as she is in the Ring camera. There's no question about that. These are the undisputed facts. Tori turns her gaze to the night sky and a bullet enters her head. Those are undisputed facts in the case. Undisputed. And so with those undisputed facts, you really only need to determine one of three things. That's what you're going to go in the back and deliberate. Did Tori shoot herself? Dr. Terry tells you that's very much a possibility. The science, speaking through Dr. Terry, says that's very much a possibility. I cannot rule out suicide. That's door number one. Door number two, did Austin shoot Tori? If we believe Austin, and Austin's the only person that puts himself there. If we believe Austin, he was present, and certainly it's possible he could have shot his friend of 10 years with no motive. That's weird. And prosecutor's not gonna come up here and offer you any kind of motive because there's none. The third option is Austin assisted Tori in a suicide. He assisted. Homicide, suicide, he assisted. There's no evidence of that. There's no evidence that Austin assisted Tori in any type of suicide. That's just random speculation, like count 3, voluntary manslaughter. And the judge is gonna read the indictment to you. You're gonna have the indictment in the back. There is absolutely no sudden, violent, and irresistible passion resulting from serious provocation. That just doesn't exist. That's just made up. Just made up. Out of thin air. Remember, the last investigator told you she came and sat down and spoke with the DA. After she spoke with the DA, she figured she was going to take these charges. Aggravated assault and felony murder. Where's this voluntary manslaughter come in? What evidence is there? Well, we're going to throw that up and just sort of see if it sticks. Really? We got it. In an effort to help you choose one of these three doors, homicide, suicide, assisted suicide, the state presented 14 witnesses. And as far as I consider it, Austin Ford is a witness because you heard his statement. 13 witnesses, you've heard from 14 people. They called 14 witnesses, but only 6 were truly helpful. The first assigned detective, Sergeant Smith, he was the initial lead investigator. What did he tell you? He learned that there were no witnesses to the shooting. Nobody ever saw Tori drive into the park. Nobody ever saw Austin drive out of the park. There are no witnesses. He learned from Tori's mother and from, I believe it was Markezia Watson. You may have written down somebody else. Tori's mother and another person that was very important to Tori's life, that Tori was suicidal. And he gave that information to Dr. Terry because she included it in her report after she did the internal exam before he ever spoke to Austin Ford. So Austin Ford didn't plant that seed. Austin Ford didn't, oh yes, I knew it, and I think she was suicidal. Forget about that. Sergeant Smith was very clear. Found the body, talked to her mother, suicidal. Talked to another female friend, suicidal. Spoke to the medical examiner, she was, according to these other important people in her life, she was suicidal. Hadn't even spoken to Austin Ford yet. So there's no Austin Ford lying and planting the seed. That's not what happened. Dr. Carol Terry, medical examiner, 6,000 autopsies. He told you the external took an hour, the internal took an hour. I suspect she's super efficient with it by now. 6,000 autopsies. And what does the science say? The science says that we can't determine if it's a homicide or a suicide. Dr. Terry by herself is the physical embodiment of reasonable doubt. The judge is going to read you the instruction on reasonable doubt, and I'm going to talk about it in a minute. Dr. Terry's testimony, Dr. Terry herself in my mind, is in fact the physical embodiment of what reasonable doubt is. The science is speaking through her. You cannot know. We don't know. You cannot know beyond a reasonable doubt. That was Dr. Terry. Dr. Terry destroyed count 3. She laid down and looked up. That's what according to Dr. Terry, that's what the science says. Tori Lang, she's the third witness. That was Tori's mom. She explained that Tori was hospitalized for mental health when she was a freshman in high school, and she also produced the rounds, the bullets, the brand which matches the 2 that were found in the park near Tori's feet. I don't care if you want to say 6 feet away, 8 feet away. That's all just silly conversation to me. That's all silly conversation to me. Why? Because Dr. Terry tells you that Tori's on her back looking up, and the gun is 10 inches away. And whether the gun is 10 inches away or 14 inches away, if you believe my client shot, she's looking up. The round discharges and it goes where it goes. There's no, if she committed suicide, it would have only gone 2 feet, but 2 more inches out, if it's a homicide, it would have gone 10 feet. That's all stupid talk. That's not even weird. That's just stupid talk. Where the rounds land have absolutely nothing to do with whether it's a suicide or a homicide. That was a waste of your time. Because we're only talking about a matter of inches. Because Dr. Terry's telling you, well, she's not laying on her back and it comes from, no, it comes directly from the side. Directly from the side. So any talk about how far out it went, that's all silly talk. Because the gun has to be 4 or 5 inches difference. Because if it's more than 4 or 5, then Dr. Terry's report changes. If it comes 4 inches in, then it has to be close range. If it goes even further out, that has to be long range. So we're talking about 4 or 5 inches is not going to change things in terms of the ejection of the round, 4, 5, 6 feet. So please, don't waste any more time on that. What else did Tori Lang tell you? Tori Lang told you she doesn't keep the firearm in the same place. Nightstand, vehicle, bag. And you have to use your common sense with that. Why is that? Well, maybe because she goes on long trips and she takes it with her, or maybe when she goes, maybe that gun keeps moving because she understands her daughter's fragile and she doesn't want her daughter to know exactly where the gun is and when it's there. You get to use some of your common sense when you approach your analysis of the evidence. Investigator Stribling, he was asked to do one very specific thing. He can't tell us if the fire was electrical or non-electrical. Why is that important? I'm not quite sure why the vehicle got burnt up or how the vehicle got burnt up. I'm not quite sure. Remember now, my client and Tori are best friends. So why would he burn up the vehicle? That's one of those weird things again. If they find the vehicle and they say, hey, we found your hair or your fingerprints in the vehicle, that was my best friend. Why wouldn't you find that? Why wouldn't you find that in the vehicle? There's no reason for Austin to set the vehicle ablaze. Absolutely no reason. Ms. Muse was important also. She told you that she could not pull any fingerprints from the shell casings. That means that there was no evidence that Austin Ford ever loaded any gun, touched any shell casings, or touched any gun. That's ultimately what Ms. Muse told us. She couldn't pull any fingerprints of value. Now, that's some of that whole ejector port. I don't recall, you may have written it down. The gun, if it was Tori's mother's gun, does the ejection port go out left or right? I thought it was right. You can write it down. Maybe we didn't deal with it at all. So when the prosecutor comes up here and does his demonstration, if you wrote down ejector port right and he comes up here with any type of mock firearm with the ejector point left, you know it's more weirdness and games. Just come straight. Honesty is the main thing. Honesty, honesty, honesty. He wants you to convict him because he lied to the police. So hopefully he'll tell you the truth. In the search for the truth, at some point in time, you have to tell the truth. Austin Ford, his interview was played with the detective. The hour-long interview was played. He said, I wasn't there. Well, listen, you got common sense. If you tell the first lie, I wasn't there, there's going to be a series of lies that have to accompany that first lie that you weren't there. So this idea that we're going to go and count the lies that all stem from the same lie. Were you there? I wasn't there. Okay, when was the last time you saw her? That's got to be a lie. What was the last thing she said to you? That's got to be a lie, because you've already lied and said that you're not there. Got it. What's the other story he says? I was there, she ended up shooting herself. Can you understand how he might have panicked as a result of seeing Tori shoot herself? Can you understand why he may not have wanted to call the police even though he didn't shoot her? I think you can probably see that. Based on his testimony based on his statement to the officer at Clayton County, Austin Ford indicated that he removed the gun and vehicle after Tori shot herself. And he says, hey, listen, the optics just didn't look good. And maybe that's the reason. Or maybe, just maybe, his judgment was impaired by, you heard it, all the marijuana he's smoking. I don't know. That's what he's telling you about. We smoked, Tori and I went to get some smoke. I had some smoke, but I want better smoke. I didn't have Zaza at the house. You heard all of that. You heard all of it. Put it all in. The good, the bad, the ugly. You heard all of it. Maybe his judgment was just impaired. He told Detective Carter he was sort of, listen, I was tied up. And I believe he was tied up, as he explains it to you. He's got to take care of his girlfriend and take care of his baby that's not his. And he's trying to make all of this work, and he's trying to keep a roof over everybody's head. And he, of course, has the gun that he gets arrested for down in Clayton County because he's trying to protect the family, but he's not lawfully allowed to get a gun because he's not 21 years old yet. And, of course, he's arguing with his girlfriend because money's short. Yeah, I can understand that, but I told you in the opening, it's hard for me to believe 8 months. I got a good friend, my good friend is dead, and the police want to speak to me, and I don't, listen, I'm gonna make some time. I'm gonna make some time in the next week. I'm gonna make some time. Yeah, I'm gonna make some time. So Detective Carter and I probably are on the same page that he was dodging, but he does in fact talk to the police, and he tells them what happened. Once I sit down, the prosecutor, he's going to get up and he's going to speak to you. He's going to give you his version of what he believes the evidence shows. And once he sits down, unlike what you saw at trial, I don't get to pop up again. Mr. Lewis, you don't have anything else to say? That's a joke, right? If it's a pop-up game, we'll keep you here all night. He'll pop up, I'll pop up, he'll pop up, I'll pop up. He gets to speak to you last. So once he speaks to you, it's over. I don't get to speak to you again. The judge is then going to tell you the law. The judge is going to tell you the law. And part of the law that the judge is going to tell you is going to concern reasonable doubt. The embodiment of Dr. Terry's testimony about science. Reasonable doubt. What's reasonable doubt? Reasonable doubt, the judge is going to tell you, is the doubt of a fair-minded, impartial juror honestly seeking the truth. That's why jury selection took a day and a half, because we've got to have impartial jurors. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. It's a doubt based upon common sense and reason. It's not a vague or an arbitrary doubt. It's a doubt for which a reason can be given after you consider the evidence, any conflict in the evidence. That's what reasonable doubt is. And the judge is going to tell you that. The judge is going to tell you mere presence is not enough. Even if you believe that Austin Ford was there in Yellow River Park, his being there is not enough. His not stopping Tori, you can probably figure that out. That's not going to be enough to convict him of murder. He didn't bring the gun. He didn't encourage her to do anything. The judge is going to tell you mere association is not enough. Just knowing Tori, being Tori's friend, that's not going to be enough. The mere association, bare suspicion is not going to be enough. The judge is going to tell you that. The judge is also going to tell you that you can't hold it against my client that he chose not to testify. I think I understand why he didn't testify, and hopefully it makes sense to you. He told them, Austin Ford, he told them, the police, I wasn't there, I wasn't there, I wasn't there. They didn't believe any of that. And when he finally said, listen, I was there, he got the handcuffs put on, and there he sits. So I don't know that talking has helped him at all. I don't know that talking has made his life any better, so maybe that probably was the best thing. Let me just sit there and let the judge tell the jury that it's the state's burden of proving my guilt beyond a reasonable doubt, because this talking thing hasn't worked for me so far. It hasn't worked for me. Sympathy. The judge is going to instruct you that your verdict must be based upon your opinion of the evidence according to the law that she will give you in the charge. Your verdict cannot be based on sympathy. The judge is going to tell you it is your duty to consider the facts objectively without favor or sympathy to one party or the other. The prosecutor wants somebody to blame. I'm not mad at that, because that's the culture now. Somebody is to blame. If we meet in an accident in a circle, you're a victim and I'm a victim. We're all victims. Whose fault is it? It's the street design. It's always going to be any adversity. We're all victims, and somebody has to be to blame. Somebody has to be the oppressor. The judge is going to tell you about sympathy. Your verdict must be based on the evidence that you heard from the witness stand. You put that evidence with the law as you deliberate, and you reach a verdict on whether or not the state proved his guilt beyond a reasonable doubt. Not all doubt, beyond the science, because the science leaves you with a doubt. And because the science leaves you with it, listen, I'm not really worrying about count 8. The concealment, tampering, I could care less about count 8. It's not about count 8. It's about the death of Tori. Because once you determine, this science thing, no, I don't know. I think Tori committed suicide. That means count 1, count 2, and count 3 are not guilty. Do you believe that when somebody sees somebody else, a good friend, shoot themselves, they then start thinking, I'm going to intentionally deprive the owner of the vehicle when I don't even know the owner of the vehicle, because I think the owner of the vehicle is Tori. I'm going to deprive the owner of the gun and the owner of the car of their Nobody's thinking about that. I don't even know where those kind of charges come from in this type of case. Once you determine that it is a suicide, you can go right down the list. not guilty count 1, not guilty count 2, not guilty count 3, not guilty count 4, not guilty count 5, not guilty count 6, not guilty count 7. And when you get to the last count, tampering, concealing, whatever it may be, you can find him guilty of that. Because under every single scenario, under the first lie, he wasn't there, under the story, I was there and this is what happened, he's got to eat that charge. As to the rest, what I ask you to do is follow the law, follow the evidence, and the only just verdict is not guilty on all the other counts other than the last one. Thank you very much, ladies and gentlemen. Thank you, Judge.
All right, thank you, Mr. Lawrence Lewis. The state, Mr. Norris Lewis, your final closing argument, please.
I'm going to take what's an unusual step from me and address the series of fallacies that you just heard from the defendant's lawyer. The first of which is that this case is based solely on the fact that the defendant lied. In 20 plus years as an attorney on both that table and this table, I have had very few cases where the defendant didn't lie, to be perfectly honest. In every case that I've had, the defense attorney gets up and says, the prosecutor believes this, the prosecutor believes that, the indictment's wrong. Literally every single case. The idea that this case is based solely on the defendant's story is literally just dead wrong. The state is not looking for a scapegoat. The state is not just looking for someone to blame, because someone has to be to blame for everything. I think you can tell by the gray hair on my face and the fact that there's no hair growing on the top of my head that I do not come from the generation that believes that everybody has to be to blame. Everyone has to have someone to blame, that nothing can be your fault. No, what I'm here for and what I'm here about is the evidence, is the facts. The things that show you that what happened to Tori was clearly not suicide. We're talking about people who said that Tori had been suicidal in the past. Sergeant Smith talked to a grieving mother who just found out that her only child probably took her gun and was now dead. This woman's world had just been upended, turned upside down, and destroyed. The only thing she can think right now is 4 or 5 years ago, when she was a freshman in high school, she did a thing that got her hospitalized briefly. She didn't say, oh, she's suicidal right now, she's running around trying to kill herself. That didn't happen. Marquisa Brown, Marquisa Watson, whatever Mr. Lewis wants to call her, did not get on this stand and say, I talked to Tori yesterday and she was just suicidal. She wanted to kill herself. She didn't want to be here. You know where that comes from? You know where that comes from? It comes from him. The person with the most interest in the case. That's where it comes from. He's the one who said it over and over and over again. You know what you didn't hear? You didn't hear anyone testify that they were asked by Tori to hurt them. Him. Only him. The person with something to gain for calling Tori's death a suicide. The proposition that Tori is feeling the pressure of being a teenage girl who is taking a diet drug and happens to have an Instagram account, of saying that, oh, she's heavy-set, she must be feeling the pressure, so she must be suicidal. That is a wild assumption. Nobody said anything like that, not even the defendant. Those things could be true, but there's literally nothing to support that other than the lawyer's assumption. Yes, we did speak about suicide in ordeal. I have to couch how I say that sometimes, because I went to law school in Louisiana, so sometimes for me it's voir dire. But We talked about that for a reason. We talked about that because based on the defendant's statements, we knew it was going to come up. And it would be irresponsible to the point of malpractice not to gauge the potential jurors' attitudes towards the topic that is largely going to be the defense. The fact that I talked about it in voir dire doesn't have a thing to do with the evidence in this case. The purpose of that entire process is simply to gauge your attitudes and your biases, and in as much as they can be identified to determine whether or not you're an appropriate person to sit on this particular case. Dr. Terry is by no means the embodiment of reasonable doubt. And I'll get into what Dr. Terry tells us and what those things mean when they are combined with what the other witnesses, what Abigail Musey tells us, what Kia Jimenez told us, what the nice ladies, Miss Carter and Miss Aparicio from the crime lab told us, and how all those things work together. Because as Detective Carter told us, this is an investigation. It's a total investigation. If Dr. Terry says, well, it's undetermined and we're done, then why do we need the Gwinnett County Police Department? Well, we need them because there's so much more to what happened than what one person has to say. And I discount nothing that Dr. Terry says. Not by any stretch of the imagination. She's a very intelligent woman. She very much knows her stuff, and that's why she said that in 6,200 or so autopsies, 700 teaching autopsies, she has seen exactly one person in a study somewhere else activate a firearm they committed suicide with their thumb, and they were looking down the barrel. The angle and the position of that gun when it fired and ended Tori's life is actually known. The orientation is known, and I'll demonstrate that for you later. But it's known. And what I'll show you is that it borders on impossible for Tori to have taken that shot, depositing that shell casing where it landed herself. And actually, both Abigail Musey and Kia Jimenez told you about semi-automatic firearms and ejection ports. Yes, they are on the right side typically. And Ms. Jimenez said on a P365, the ejection port is on the right side. The angle at which that shell casing is thrown is telling of which way the ejection port was pointing. Plain and simple. I'll explain that further. The fact that there are no fingerprints found on the shell casings of the defendants is immaterial. We know that it was Teresa Lang's gun. It was probably loaded when it came to be in Yellow River Park, and frankly, it was probably loaded by Teresa Lang. So the defendants' fingerprints on, or lack of fingerprints on, are not material to whether or not he pulled that trigger. Somewhat material that he took it with him when he left in Tori's car. Now, the way a theft is proven in Georgia, a person does not have to specifically think, well, I want to deprive the owner of this notebook, so I'll take this notebook and I'll walk away, and that's because I want to deprive the owner of it. No. That is, as I said in the beginning, those are words. Words are important. Words are used differently in the law than they are in common usage. And so the law requires that you find that they intended to deprive the owner of the thing. It doesn't mean that they had to think to myself, I'm going to deprive the owner of the thing. The evidence of that is that they did something with the thing that was not taken back to the owner. And so if I throw a firearm into a pond, I'm certainly not about to take that back to the owner. If I park the car in the cut, if I abandon it, give it to someone else, sell it, nobody actually knows what he did with the car. I can't tell you whether or not he burned the car in DeKalb County. Even if I did know, that's a DeKalb County issue because it didn't happen here. Jurisdiction prevents me from doing anything about what happened in DeKalb County. Investigator Stribling was clear. That car burned exactly where you saw it, which is in DeKalb County, which if someone set the fire in DeKalb County, irrespective of whether or not it had accelerant, that's a DeKalb County problem. Reasonable doubt is not beyond all doubt. It is not to a mathematical certainty. There are no percentages that you should use to determine what reasonable doubt is. It is the doubt of a fair-minded juror honestly seeking the truth. And that's what we're here for, truth. Evidence comes in two different ways, direct and circumstantial. Direct evidence is what someone tells you they saw. When Kia Jimenez looked, direct evidence that those two shell casings, at least in her learned opinion, come from the same gun based on her observations. That there were no drugs other than a prescribed drug in Tori's system was the expert opinion of Denise Carter. That is direct evidence that Tori was not blitzed out of her mind. She was testing for cocaine metabolites and certain amphetamines, and there was no indication that there was a need to test for anything else. When Chris Aparicio tested the blood on Tori's thigh, we learned that that's her blood. We also know that that couldn't be her blood because she couldn't move afterwards, but it's direct evidence that that's her blood. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. So, if there is a shell casing in a certain direction from a body, we know it was fired by a semi-automatic firearm, we can gauge at what approximate direction, what approximate way that ejection port was facing. Based on the testimony of Dr. Terry, I can tell you exactly where that firearm was. Now, that's not direct evidence because no one saw, well, except for the defendant, but nobody else saw where that firearm was and could say, I saw that firearm in that position 10 to 12 inches from Tori's head. But it's circumstantially, I can tell you exactly where it was. There is no legal difference between direct evidence and circumstantial evidence. Evidence is evidence. And of course, there are rules of evidence. You did notice there were a couple of objections. You can only be shown that which is admissible. You are also the finder of fact. Part of being the finder of fact is that you judge the credibility and believability of each witness. Their opportunity to see, their opportunity to hear. But one major thing to consider in what a witness says is their bias in the case, their interest in the case, and whether or not their testimony is probable or improbable. There are 8 counts on the indictment. As I said, there are sometimes charges in the alternative. One thing about people is people are wildly unpredictable and you never actually know what they're going to say. And so sometimes you include charges that don't immediately make sense. I won't say that, that's not true. Sometimes you include other charges because crimes can happen more than one way, quite frankly. But when I'm done, I will ask you to find this defendant guilty of counts 1, 2, 4, 5, 6, 7, and 8. Now, let's talk about what we know. We know from Dr. Terry, and these are facts, we know from Dr. Terry that the gun was about 12 inches from Tori's head when it was fired. That's based on her observations in the pattern of the wound, science. That it went straight across Tori's head. right around the front of her ear, straight across to the other side, severing her brainstem. Based on that, Dr. Terry was able to tell you that Tori was lying in the position in which she was found when she was shot. Blood flow, the pool of blood on the ground, the particulate matter on her legs, on the back of her shirt, the appearance that there was no drag marks, no indication on her skin, no abrasions. All of that tells us she was right there. We know there were 2 shell casings, and we know where they were. We can see their approximate distance and angle from Tori's body when officers come and ask they were found. We know that Tori was not alone. We know she wasn't alone because Tori wasn't going to move the firearm. Tori couldn't move the car. The firearm itself was never found. There was not even an idea of where to look for 8 or 9 months, when any number of things could have happened to it. Could have sank deep into the mud in the pond, could have been somebody else swimming, could have found it, picked it up, and carried it off somewhere. If that's even the right pond, if that's even the right point in the pond where he threw it, depending on how far he threw it into the pond. Did other things fall into the pond? There's any number of reasons why the Hall County dive team couldn't locate that firearm. We know that the car was found in a nature preserve in DeKalb County. We know that it was burnt to the frame. We know that the defendant lied about being there. He lied about seeing anything. He lied about looking for Tori. He gave the police other people to look at. He tried to send them off in another direction. Don't look at me, don't look at me, look at him. Look at Scoop. Oh, Scoop would have done it. Scoop's a bad dude. You know, Scoop be hitting licks. Scoop be doing scams. He pops perks and Molly, and Scoop's bad. Look at Scoop. Scoop was completely cleared. He did not come forward and volunteer that he was there after 8 months because his conscience was getting the better of him, because the anguish that he added to this situation for the Lang family was just eating up at him. He got caught. Detective Carter figured out where he was based on where his phone was. Detective Carter figured out that he turned his phone off on the way into Yellow River Park. Turned it off. It wasn't pinging anywhere. Suddenly, just went dark. Someone tried to call it. His girlfriend tried to call it. Not answered, because it was off. Why you turn your phone off when you're going into the park at 11 o'clock at night with your best friend? Why does it come on shortly before you wind up home? We know there were 2 shell casings. We know that there were similar marks left by the gun that fired them. Most likely they came from the same gun. A SIG P365. We know that Teresa Lang owned a SIG P365 and that she had Aguila ammunition in the box in which the 365 was located. We know from Kia Jimenez and Abigail Musey how semi-automatic pistols eject shell casings, typically thrown out and to the right. SIG P365, which Ms. Jimenez was familiar with, has an ejection port on the right, and it throws out into the right. We know what the condition of the ground was. It was wet, compact dirt. There was some vegetation, but it was largely just dirt. But it's not like a hard concrete floor that's been waxed within an inch of its life. A shell casing hitting that kind of ground isn't just going to skitter around, bounce off, and roll away. It's largely going to stay about where it lands. And like I said, based on Dr. Terry's findings, we know exactly where that gun was when it was fired, when the shot that killed Tori was fired. We know exactly where it was because we know exactly where Tori was. We know that blood on her thigh was her own and that she didn't have anything wild in her system. We know that the defendant turned his phone off going into Yellow River Park. It's not that he stopped answering it, it was still pinging near there. No. It was off. It was off so he couldn't be tracked. We know that for almost 9 months, he lied. He concealed the truth. He evaded police. He dodged them, giving up no knowledge that he had about Tori's death, knowing that he was doing everything he could to prevent them from determining whether or not her death was unlawful, whether or not he killed her. Based on this photo, we're looking down at Tori as she was found. We see where the wound was above her ear. We know that that firearm had to be 10 to 12 inches down here, which would be midway through where her forearm is right now. It had to be there. It absolutely had to be there. 10 to 12 inches, about the length of a sheet of paper from her head in that position, which means that in order to fire it herself, she would somehow have had to contort her right arm into a position to hold that thing 10 to 12 inches from her head. To add to that, we know where the two shell casings were. There's one further away. This one probably was not the shot that killed Tori. This probably was. It might be, it's a few feet, maybe 8 feet, 6 feet from Tori's body off to her right, which means that the ejection port from that firearm was facing this way. It was facing towards this shell casing, which adds yet another degree of difficulty to how Tori would have had to fire that shot if she in fact fired it herself. It borders on impossible. Impossible to the point of riding a unicorn, winning the lottery while getting hit by lightning. It's a 1 in a million thing, but is it impossible? No. Mr. Lewis said, oh, it's Dr. Terry said it's very much a possibility. That's not what she said. She said it is a possibility. Allow me to assure you that this is not a live firearm. It does not have a firing pin. It is incapable of firing a round. It has been cleared with the Sheriff's Department, and that's why they have not jumped me when I pulled this thing over here. We know that Tori's head was in about this position when she expired. We know that, you know what, let me not do that way. That's not much better. But we know that on her right side, 10 to 12, I'm on the left side because I don't want to point at the audience, even though it's not a gun and can't fire. But we know that this gun was about this far from Tori's head. Now reversed, it was about that far from Tori's head. It had to be in line with the wound. Her head was on the ground, so the firearm had to be down here. Now, because the ejection port had to be to the right, this is the way this firearm had to be when it killed Tori. Which means she would have had to contort her hand, her own hand, in such a way to create this. So with the ejection port having to face towards my feet, I can only get this thing that way if I fire it with my thumb. And not only do I have to have it this way, but I have to produce a perfectly straight shot across the back of my head just in front of my ear. That borders on impossible. You cannot do it you cannot do that naturally, the way a firearm is naturally held. It's simply not possible that way. The only way it happens, and Dr. Terry did say that, the only way it happens is with your thumb. $6,100 to $6,200 autopsies she was the lead examiner on. 700 teaching, 20 years, 3 Georgia counties. She has seen exactly 1 suicide where the thumb was used. She has seen exactly 1 where the thumb was used. And that person was looking down the barrel of the gun. I'm not necessarily going to look down the barrel of the gun and play this thing myself enough. But looking down the barrel of the gun, it was done this way. The only way Tori activates that gun herself is with her thumb. The only way she does it and produces that wound is if she produces a literal straight and level shot. What is more likely is that there was someone else lying next to Tori who pulled the trigger, probably lying prone. They would have been able to produce that shot. We know that the only other person there was the defendant. That's not basing a case on a lie. That's basing the case on an evidence. Oh, the lie is part of it. But that's not just, oh, he lied, he's guilty. That's ridiculous. Those scientific facts that Dr. Terry testified to, the wound path, her almost instantaneous death, that there is no movement after a brainstem is severed and her position at her death. What she did not know, and she had some indication, yes, but she did not conduct any investigation into the defendant himself. She did not know the entirety of his lies. She did not know anything about what his interview with Detective Carter was. She didn't know that his Google records placed in there. She didn't know where his cell phone records put him. She didn't know necessarily about the car that was torched in DeKalb County because she performed her autopsy 2 days before it was even found. Those things are not her role. The suicide notion comes from the defendant. The only person who we hear say that Tori was suicidal in July of 2021 is the defendant. Nobody else stood here, said that Tori asked them to hurt her. No detective who talked to anyone even said that someone said that. The only place that comes from was the defendant. That shot would be hard to reproduce shooting naturally by experience.
Pause for a second. Please step out of the courtroom. You are excused from the courtroom, sir. I apologize. Please continue.
It would be difficult for an experienced marksman to produce a shot that straight with no up, down, no left, right deviation. Literally straight across the brainstem. But I didn't want you to believe Tori did it with her thumb on a whim in the park while staring up at the sky. That's stupid. When he finally tells some modicum of truth, he's still lies. Because what he said, well, I had the gun, I got it from her, I put it on the ground. I tried to hug her, but she pushed me away, grabbed the gun, and just shot herself in the head. Seriously? With what Dr. Terry told us, is any of that even possible, let alone true? Never said he was at the park. Didn't mention the gun till he had to. Didn't mention the car till he had to. paints himself as some sort of white knight who was the only person who cared about Tori, who was the only one who recognized that she was in distress, who tried to help her. You can tell when he's lying and how he's lying based on the way he interacts, both in particular with Detective Carter in those 2 long interviews. And I admit that I hated playing interviews that long. I apologize for that, in as much as we had to sit there and listen to them. But what I wanted you to hear is how every second there's a pause, the defendant starts talking again. Starts talking to saying something else that favors his story, something else that makes him look a little bit good, because he's trying to get Carter to believe the lie. He figures in his mind, one more sentence, one more word, she'll finally believe it. If I just say one more thing, it'll put her over the top. He does that throughout the phone call. He does that at the jail. Ladies and gentlemen, your job is to seek truth. Yes. It is your job to seek truth. All right? It is your job to seek truth using the entirety of the evidence, using the entirety of the investigation, the observation of Casey Smith, the work that Sergeant Smith did before he was reassigned, the work that Detective Carter did after she got the case. What Teresa and Tanya Lang told you about, not only about Tori, but about the fact that they didn't tell Austin Ford he could take their stuff and throw it in the pond or leave it somewhere to be burned up. Ms. Boone Perkins, who provided ring camera that partially debunked part of the defendant's story. Dr. Terry, who, while again, she did find that the cause of death, the manner of death was undetermined, she did show us and tell us that it is wildly unlikely that Tori committed suicide. Did she use those words? No. But because it was possible, she couldn't change her ruling. Because something is possible doesn't make it likely, and it sure doesn't make it reasonable. And of course, Ms. Carter and Ms. Aparicio. I really just don't want the last image that you see of this beautiful, effervescent young woman to be her lying under a tree. But I do want you to go back into that room and find this defendant guilty of felony murder, aggravated assault, 2 counts of possession of a firearm during the commission of a felony, and 2 counts of theft by taking and concealing the death of another. Because looking at the evidence as a whole, in total, there is no circumstance that exists other than that defendant killed his best friend.
All right, Mr. Lewis, if you can remove your props and if you can move the podium.
Where would you like the podium, Your Honor?
Just push it out of the way for me, please. In just a moment, I'm going to instruct the jury on the law. No one will be permitted to enter or leave the courtroom while I am giving these instructions. They are lengthy, so if you want to leave, please leave now. All right, Ms. Floyd, please do not let anyone enter or exit the courtroom. All right, members of the jury, you are considering the case of the State of Georgia versus Austin Tyree Ford. The district attorney has indicted the defendant for the offenses of felony murder, aggravated assault, voluntary manslaughter, possession of a firearm during the commission of a felony, 2 counts, theft by taking, 2 counts, and concealing the death of another. The indictment has previously been read to you. And let me back up. You're each going to have your own individual copy of the entirety of these written instructions with you in the jury deliberation room. so you don't have to feel the need to take notes on them because you will have the entire instruction individually, your own copy with you. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense or offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate it or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After considering all the facts and circumstances of the case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit this defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit this defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I am giving you to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight that you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. You as the jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observed it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. The testimony of an expert, like that of any witness, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent the defendant was informed of his rights. You may consider the duration and condition and voluntarily made. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and made as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights, and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. The defendant had a right to remain silent. If the defendant chose not to remain silent, anything he said, wrote, and signed could be used as
The 11 Alive Storm Trackers. It's how you'll be prepared and stay safe. 11 Alive Morning News.
We began with breaking news this morning.
Is where you know what's happening now.
11 Alive is live on the scene.
Where you can confidently plan ahead.
This severe weather is intensifying.
By knowing what's coming overhead. And where Atlanta's traffic expert
We've seen delays almost 30 minutes worth of
helps you get there on time, every time. 11 Alive Morning News is where you start the day prepared. Watch weekdays 5 to 7 a.m.
If you see breaking news or severe weather near you, snap it and share it using Near Me on the 11 Alive News app. Want to verify if something's true or false? Record your question and send it. Download the 11 Alive News app to use Near Me.
11 Alive News at 11 p.m. is where you find out what's happening now across Metro Atlanta.
We begin tonight with breaking news out of Cobb County, where a neighborhood is now...
Where you stay a step ahead of severe weather.
Our storm risk has now been upgraded to a...
And the only place where you can verify fact versus fiction.
11 Alive can verify that claim is false.
11 Alive News at 11 p.m. Where you end the day ready to take on tomorrow.
Weather can't run from the 11 Alive Thunder Truck. A mobile weather center with the power and speed to chase down the strongest storms and bring you on-the-ground conditions. The 11 Alive Thunder Truck, sponsored by Landmark Dodge. Fighting social inequality is on all of us. That's why 11 Alive is committed to sharing diverse perspectives, exposing injustice, and finding solutions. Voices for Equality, sponsored by Georgia Power and our other partners.
The 11 Alive Storm Trackers. It's how you see weather happening now across Metro Atlanta.
These severe storms are now closing in.
We could be talking about damaging winds, hail, and...
How you can plan ahead by knowing what's coming overhead.
Heavy storms are rolling in.
Expect pop-up thunderstorms and rain all day long.
And how you'll be weather ready wherever you are.
We expect at any moment a tornado warning could be issued.
The 11 Alive Storm Trackers. It's how you'll be prepared and stay safe. 11 Alive Morning News.
We began with breaking news this morning.
Is where you know what's happening now.
11 Alive.
Rights, and that he understood and gave up those rights, then you must disregard the statement entirely and give it no consideration in reaching your verdict. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by the defendant and offered by the state. The jury may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. However, proof by evidence beyond a reasonable doubt that the crimes alleged have been committed may constitute supporting evidence of a defendant's statement, if any, should you so find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not other evidence sufficiently supports a defendant's statement so as to justify a conviction. If you find that there was a statement made by the defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of the guilt of this defendant beyond a reasonable doubt. During the trial, you viewed and heard audio and video recordings of interviews purportedly between the defendant and the police. You saw and heard the interviewing officers make certain statements to the defendant. You are instructed again that the declarations or statements of the officers are not evidence, and you should not consider such as evidence unless such statements are proven to you by other competent evidence. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witnesses offered for this purpose. You should consider all of the factors previously charged you regarding credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are as follows: the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view the witness claimed to have, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator, and the length of time between the crime and the out-of-court identification. It is for you to say whether under the evidence in this case, the testimony of the witnesses, and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove, beyond a reasonable doubt, the identity of this defendant as the person who committed the crimes alleged in the indictment. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are credibility and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. This defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act or omission to act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but simply means the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that The acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Knowledge on the part of this defendant that the crimes of felony murder, aggravated assault, voluntary manslaughter, possession of firearm during commission of a felony, theft by taking, and concealing death of another were being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of the alleged offense, then it would be your duty to acquit this defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes of felony murder, aggravated assault, voluntary manslaughter, possession of firearm during commission of felony, theft by taking, and concealing death of another were being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that criminal actions shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Gwinnett County, Georgia, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by direct or circumstantial evidence or both. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. I will now define the offenses. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. Aggravated assault is a felony, which I will define for you shortly. The state does not have to show that the defendant acted with malice to prove felony murder. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For voluntary manslaughter, the evidence must prove that the defendant caused the death of another person under circumstances that would otherwise be murder, and acted only because of a sudden, violent, and irresistible passion that resulted from serious provocation, which was sufficient to excite such passion in a reasonable person. If you decide that enough time passed between the provocation and the killing for a reasonable person to have cooled off and regained judgment, then the killing is not voluntary manslaughter. When a defendant unlawfully injures another person, you may find that the injury caused the other person's death only if the state proved that the injury was itself the cause of death, directly and significantly contributed to the cause of death, or significantly sped up the death, even though the death would have eventually occurred. Aggravated assault. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For possession of firearm during the commission of a felony, the state must prove that the defendant had a firearm on his person while committing a felony, which is a crime against or involving another person. Felony murder and aggravated assault are felonies which have already been defined for you. For purposes of this offense, a firearm includes any handgun. Theft by taking. A person commits the offense of theft by taking when that person unlawfully takes any property of another with the intention of depriving the other person of the property, regardless of the manner in which the property is taken. Deprive means to, without justification, withhold the property of another permanently or temporarily, or to dispose of the property so as to make it unlikely that the owner will recover it. Property of another includes property in which any person other than the accused has an interest. When value is an element of an offense, as in count 7 of the indictment, charging theft by taking of a vehicle, the value that must be proved by the state is fair market value of the vehicle at the time of the taking. Fair market value is defined as the price agreed upon by a seller who is willing to sell but not compelled to do so, and a buyer who is willing to buy but not compelled to do so. Value must be proven by the state beyond a reasonable doubt for the item alleged to have been taken in count 7 of the indictment, the vehicle. But value does not have to be proven by the state beyond a reasonable doubt for the item alleged to have been taken in count 6 of the indictment, the firearm. The value of the property alleged in count 7 of the indictment, the vehicle, is an additional element that must be proved by the state beyond a reasonable doubt. I charge you that the state must show that the value of the vehicle, which was the subject of the alleged theft in count 7, was $5,000 or more. The form of your verdict should also include your finding as to the value of the vehicle supported by the evidence beyond a reasonable doubt. Concealing the death of another. A person commits the offense of concealing the death of any other person when that person hinders the discovery of whether or not another person was lawfully killed. If, after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia, did on or about July 27, 2021, commit the offense or offenses of felony murder, aggravated assault, voluntary manslaughter, possession of firearm during commission of felony, theft by taking, and concealing death of another, as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of one or all of these offenses, or if you have any reasonable doubt as to the defendant's guilt on one or all of these offenses, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty of the offense or offenses for which you do not believe the defendant is guilty. Let me take a moment to explain the verdict form. You're going to have a written verdict form with you. The verdict form is going to give you an option for each of the 8 counts of the indictment. For example, count 1 is listed as felony murder, and you will have 2 options. You will choose one option for each count, but you must render a verdict on all 8 counts. So for count 1, you will either check, we, the jury, find the defendant guilty of felony murder, or you will check, we, the jury, find the defendant not guilty of felony murder. So you will indicate your verdict form for each of the 8 counts. The only thing that is slightly different that gives you more than 2 options is count 7, which is the theft by taking of the vehicle, where you also have to encompass a verdict as to the value of the vehicle. So on count 7, theft by taking of the vehicle, your choices are guilty of the vehicle of a value of $5,000 or more, or guilty of the vehicle of a value between $1,501 but less than $5,000, or guilty of the value of the vehicle less than $1,500, or not guilty. So on the theft by taking of the vehicle, you have to render a verdict of guilty or not guilty that also encompasses what you believe to be the value of the vehicle based on the evidence. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of this defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. You are also to only concern yourself with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to act as the foreperson. The foreperson will manage your deliberations and will sign the verdict form to which all 12 of you must freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about the case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is as to each of the 8 counts, it must be unanimous on each count, that is, agreed to by all. The verdict must be in writing and signed by your foreperson, dated and returned to be published here in open court. A few more things. You will have, when you begin your deliberations, a copy of the indictment, a copy of the verdict form. You will each have a copy of the instructions on the law that I have given to you, and you will have the relevant evidence that has been admitted and that is permitted to go back with you in the jury room. When you get back to the jury room, you are to select your foreperson, but do not begin any deliberations until you have received all of these items that I've indicated that will come back with you in the deliberation room. 14 of you were selected because many things happen, and we still may have a need for all of you in some capacity, but the first 12 jurors that were selected will be the 12 jurors that will begin deliberating on this case. The last 2 jurors that were selected are our alternate jurors who will remain with us but be kept separate from the first 12 jurors unless one of the 12 jurors is disqualified for any reason, and then you will need to join in the deliberations. So our first alternate is juror number 34, Mr. Reed, and juror number 43, Mr. Perry. So I'll ask the bailiffs to keep juror 34 Reed and juror 43 Perry separate from the first 12 jurors. But please remember the alternate jurors during any breaks. If there are any questions that you want to ask the court about any legal concepts, or you need to see evidence that perhaps is not with you in the jury room, then that will need to be a note that is written by the foreperson and presented to the bailiff for any questions to the court. You don't have to ask me if you need to take breaks, but you will need to let us know, excuse me, you will let us know at some point if you want to cease deliberations for the day and continue into tomorrow. We are on your schedule, so at this point, you will determine your breaks and how long you deliberate until we reach a verdict. All right, I'll ask that you take all of your notepads and pens as well as your personal belongings and follow the bailiffs. All right, any exceptions to the court's charge from the state?
No, Your Honor.
From the defense?
No, thank you, Judge.
All right, I'll need you all to agree on what exhibits will go back with the jury and to place what goes back on the record and what does not go back on the record.
Because they need to compare the VIN number on it. They don't have the VIN number, so it's just not really speaking to stuff. It's state agency finding.
I assume you follow.
Oh, yes, I am.
I assume so.
Yes, yes.
Does not. Does not. Does not. As much as I hate that picture. Does.
we're ready to place what goes back and what does not go back on the record.
I think the simpler way to do it would be to just place what does not go back.
Okay.
Stacy's Exhibit 15 is a thumb drive, though technically it could go back with no means to play it. We're going to withhold it. I think that's by agreement.
Yes.
Stacy's Exhibit 58, 57, 56, 55, 43, 42, and 41 do not go back with the jury.
All right, if you will hand those exhibits to the court reporter, she will maintain possession of those exhibits. And you agree that all exhibit numbers that were not just referenced on the record will go back with the jury?
Yes, Your Honor. Yes.
All right, and then I will hand you as well the indictment where issue was joined and the verdict form. And if you will, one of you will grab the 12 copies of the request to charge that have been set aside for the bailiff. We can put everything in one pile. All right, that is everything that will go back for the jury. I will ask the attorneys for each side to leave your best form of contact with, write it on a piece of paper and leave it with the deputies or the court reporter so that they can share it with the bailiffs.
Bailiff took our numbers already.
All right, and so then we will be in recess until we have a question, a verdict, or they indicate that they want to recess for the evening.
Thank you, Your Honor.
All right, everyone needs to sit close by. I will only wait a short, reasonable amount of time to address any questions or verdicts. So, in the courthouse, in other words.
I got you, Judge.
All right.
I'm just trying to figure what the alternative is. You tase us. I'm going to be here. I'm not going anywhere.
All right, and Mr. Lawrence Lewis. Please. Did you didn't bring your laptop in?
I can go ahead and get it.
We'll see where we land. Oh, not yet.
Okay.
Is he bringing Mr. Ford out?
I don't think you gave anybody that.
Did.
Oh, did you? I didn't hear
I
you.
think it went to,
Yeah, I just heard.
okay.
I missed that, Judge, sorry.
I didn't hear you either.
All right, let's go back on the record. We have a question from the jury. It is marked as Court's Exhibit 6. It is dated April 27th, 2023. Dear Judge Fluker, the jury would like to see the prop gun used by the prosecution during closing arguments. Thank you. Elizabeth McKenna, number 31, jury foreperson. Will you show it to both sides, please? Mr. Umberg. All right, give me just a second. All right, proposed response or reaction from the state first. I mean,
It wasn't introduced into evidence, it was
demonstrative aid.
used during closing. I don't know that it would be appropriate to send it back with them.
Reaction, response.
I think that's the only legal response. I don't even know if I would call it demonstrative evidence. It was an aid used during closing, which is not evidence. So I don't think that they get to see it again or touch it, or I don't think it goes back with them to closing. I don't know exactly how you're going to say that though.
I mean, I guess I can call it a prop that was used in closing argument that was not part of the admitted evidence.
That's fine, Judge.
That's fine with me.
All right, let me formulate that exactly and read it back. Give me just a moment. Right, our proposed written response is, we are unable to provide you with the prop gun as it was solely used during the state's closing argument and was not admitted into evidence by the court. Any exceptions from the state?
No, Your Honor.
From the defense?
No, thank you, Judge.
All right, I'll have Mr. Umberg show the court's response to the jury and returns Court's Exhibit 6 to the court reporter. All right, we'll just remain here momentarily until Mr. Umberg brings that back to make sure there's not any follow-up questions. Mind stepping out and just making sure Mr. Umberg knows that I wanted him to come back to make sure there was no follow-up.
Sorry, Judge, for the delay. They're formulating another question. I thought we could just get it back.
All right, we'll just be at ease then and wait for the follow-up question. I'll hold on to this. Thank you.
And for your information, they're saying that they want to go to 4:45.
Okay. All right, so we will wait. Apparently there is either a follow-up question or a different question, and we are being advised that the jurors want to deliberate until about 4:45 today if they do not have a verdict before that time. Ellen, so we have them. Ford, back out, please. Is this the only one we're expecting?
Yeah, they might have some more tomorrow.
Okay. Let us go back on the record. I have received a subsequent note from the jury that I have marked as Court's Exhibit Number 7. It is dated April 27th, 2023, and reads as follows. Dear Judge Fluker, the jury would like the measurements of Sig Sauer 365. Thank you, Elizabeth McKenna, number 31, foreperson. Right, so obviously I don't think there was any evidence about the measurements of the purported firearm. Does the state have a suggested response?
I think the only response is that
Those are not in evidence. Similar to the last no judge.
All right, let me propose a response. Give me a moment. All right, my proposed response reads as follows. Your verdict must be based on the testimony and admitted evidence, documents, photographs, etc. You must recall the evidence. I am unable to supplement any additional requested evidence after the evidence is closed by both sides. Any exceptions to the court's response from the state?
No, Your Honor.
From the defense? All right, I'll ask Mr. Umberg, the bailiff, to give courts 7 and the court's response to the jury. Are we anticipating an additional note, or are they just asking to be excused for the night at 4:45?
I think they're just asking to be excused for 4:45.
All right. Does either side want me to bring them back into the courtroom to remind them of their precautionary instructions, or let them be excused from the deliberation room at 4:45 for the evening?
I don't have a problem with the second option, Judge.
I don't either.
All right, so Mr. Umberg, they can be excused at 4:45 if they have no additional questions to report back tomorrow. They can let us know if they want to come back at 8:30 or 9. We're on their schedule, so they need to let us know what time they want to come back, and you can notify the attorneys. All right, thank you. All right, so I am going to step off the bench, and I am assuming at this point that we will be in recess until tomorrow morning, unless the jury comes back with an additional question before 4:45. The bailiff will let you know if they're going to resume their deliberations at 8:30 or 9. That's up to them. All right, so we will be in recess unless there is an additional question before 4:45. All right, and Mr. Ford can go back with the deputies.
Will you come back on at 4:45?
I do not intend to come back on the bench, so.
4:45, then I'll leave.
Correct.
Thank you, Judge.
Thank you. I will not come back on the bench unless there's a question. Number 6. But I am going to wait until I get court's exhibit number 7 back, but you can be excused. I will wait just to make sure that I secure that court exhibit.